We've got a very full menu this afternoon, so I'll get straight into our first session, which is a panel discussion on the role of the protector following ex-trusts and the Piedmont and Rivera Trust cases. And to keep proceedings as civil as possible, we've got a protector of our own. We've appointed Mr. Ham, who I'll hand over to now.
Thank you, Jonathan. What we now call protectors have been around for a long time. I'm fond of pointing out that we are almost exactly 100 years after the creation of the famous Vesti settlement, which has a dubious distinction of having been to the House of Lords twice, but which contained provisions for what we would now call protectors, namely the authorized persons, the two Vesti brothers who were given powers to control the investment of the settlement. The inclusion of provisions for protectors have become commonplace, particularly in the case of offshore settlements. Indeed, some of the clients of the category who think that the most important document is the letter of wishes think that the protector is almost as important as that. But though there have been protectorships for a long time, there was until comparatively recently very little learning on the subject. There wasn't anything in the main textbooks or much case law. That's all changed subsequently. There are now 2 monographs on the subject, as well as a chapter in the International Trust Laws written by members of Wilberforce Chambers, which has the distinction of being cited both in the Pugachev case and in the recent ex-trusts case in Bermuda, though I think it's fair to say that Mr. Justice Burse in Pugachev thought that the chapter was written by David Hayton. Much of the debate has focused on the question whether protectors are subject to fiduciary obligations, but a trio of recent cases in England, Bermuda and Jersey, and I rank them according to chronology rather than anything else, have considered the position where trustees have dispositive powers subject to the consent of the protector. I'd add that there is a 4th case, which is both unreported and presently unreportable because the relevant file is sealed in the Isle of Man, where it was held that the Manx equivalent of Section 57 of the Trustee Act enabled the court to dispense with the requirement of the protector's consent to an appointment being made by the trustees. In order to explain the debate about ex-trusts, etc., I'm going to ask Michael Ashdown, who was involved in ex-trusts, to tell us what it's all about.
Thank you, Robert. And for the moment, at least, I will try to be even-handed about the debate on this topic, although, as will become apparent later, I do have my own firm views as to which way we should be going. So just to set the parameters, we're talking here obviously about primarily offshore trusts, although you do sometimes now see protectors in domestic English trusts. And we're talking about protectors that are given particular types of power. Now, protectors are often given powers to, for example, appoint trustees, sometimes to remove them, sometimes even to change the governing law of the trust. And we're less concerned with those sorts of powers for the protector to act themselves. We're more concerned with the kind of power that Robert has already referred to, which is to say consent powers, where the trustee is given a power, say, to make appointments of capital. It's probably the simplest example, and such appointments are subject to the protector giving their consent. The protector is often seen as being rather closer to the settlor and their family, better placed to know what they would want. And the trustees in these cases are generally offshore for tax reasons, both sort of physically very distant from the settlor and often with no prior connection. They are professional trustees who have taken it on a purely commercial basis. Now, there have obviously been cases, as Robert's alluded to, concerning protectors and their role previously, but they've tended to concern quite narrow points. So are they fiduciaries? Can the court remove the protector? That seems to have been litigated in Jersey in particular on a number of occasions, but none of these cases really get to grips with what the role of a protector is. Now, that has changed with the trio of recent cases that Robert mentioned. So first of all, the PTNZ case in England in the High Court just over a year ago, not a decision of a High Court judge, but a decision of Master Schumann, now of course Chief Master Schumann. That was probably the first case that anyone's aware of that grappled with what in general terms is the role of a protector exercising a consent power. That was then followed by Trusts, the case that I was involved in Bermuda, which argued last summer, and judgment came out in September, decision of Justice Cayley. And then finally, the Piedmont and Riviera Trust decision in Jersey, which I think was actually heard almost concurrently with Trusts, such that the Trust decision was only brought to the attention of Sir Michael Burt in Jersey after the hearing had finished, although before he handed down his decision. And the question which is at the heart of all three of these is, what is the proper role of the protector in deciding whether or not to give its consent where the trustees have a power they propose to exercise and can only exercise with protector consent? And there are two views, which I'm going to call the narrow role and the wide role, because that's the terminology that was used in Trusts, where this was articulated at greatest length. The narrow role is that the protector is perfectly entitled to engage with the trustees, talk to them, bring matters to their attention, act as a sounding board. But ultimately, if they think that the trustees are making a decision which is a proper and lawful decision for them to make, then the protector should give their consent, even if the protector might, having approached the matter for itself from fresh, have reached a different view on the merits. That's the narrow role. The wide role is that the protectors have an entirely freestanding discretion to do whatever they want. They can refuse consent to a perfectly proper exercise of the trustees' powers simply on the basis that they themselves take a different view. Now, it would of course be helpful, although I suppose we wouldn't all be here for this webinar, if the courts had reached a consensus view on this. What in fact we have is PTNZ, where Master Schumann pretty much plumped for the wider role, although it's fair to say that the consideration of this point was one point among many that were before her on that occasion. In Trusts, where this was the principal issue before the court, the Justice Cayley went for the narrow role, and I'll be explaining later. I think he was right to do so. In Piedmont and Riviera, it's difficult to say exactly what was decided. Superficially, Sir Michael Burt prefers the wide role approach, although he does also express the view that protectors should usually consent to proper trustee decisions, even if they might have done differently themselves. So he rather blurs the line. So that is where the law stands now. We have three cases in three different jurisdictions, each taking slightly different view: the wide role in PTNZ, the narrow role in Trusts, and the wide role possibly, or maybe something of a hybrid, in Piedmont in Jersey. And on that, I'd like to hand back to Robert.
Yes, I'm going to give Michael a chance to put on his armour when he discards neutrality and goes into bat for the narrow view, because what we'd like to do at this stage is have a poll indicating whether the participants support the wide role or the narrow role. And I'm glad to say the poll has appeared on my screen, though I'm told that I've been disenfranchised and can't vote. So if you would like to vote now, and what I suggest is that Michael continues while the votes come in and are polled, And then I'll tell you where we've got to. And the idea is that at the end, we will rerun the poll and see if anybody has changed their mind.
Thank you, Robert. Yes, I will put my tin hat on and go to the priest to somewhat mix metaphors. I should say, in the interest of balance, Gilead will be following to explain why he thinks that everything I've said is hopelessly wrong. You of course, may form the view that he is hopelessly wrong to think so. I can't do justice to Justice Cayley's 59-page judgment in a few minutes now. This was argued for 4 days in the Bermuda court, but oh, there we go. We're very evenly balanced at the outset. Well, we'll see where we finish at the end. So 52% of you have plumped for the wide roll and 48% for the narrow roll. What is it about those percentages? Anyway, what we're talking about really is a default, because everyone in all of these cases has accepted that, and this is a point we'll be returning to, that it would be perfectly in order for a settlor to make express provision in their trust instrument, and subject to all the usual questions about what they've said and what it means, perfectly proper for them to decide the answer to this question in advance. The reality, of course, is that settlors have not done so historically, and there's no real indication of any inclination to start doing so now. So the law needs a workable and sensible default option. What is the position of a protector? What is their role if the settlement doesn't tell you explicitly? Well, I just want to say 3 things about this. The first is about the distinct roles of trustees and protectors. The narrow role approach keeps the trustees in the driving seat, which is absolutely where they should be. The power of appointment in these cases is conferred on the trustees, and what is conferred on the protector is merely the power to consent or not to its exercise. I don't think anyone disagrees that that means that the trustee and the protector have from the outset different constitutional roles within the structure of the trust that the settlor has set up. And it shouldn't really be contentious that the role of the trustee is to administer the trust, to decide whether to make a capital appointment, and to do so in accordance with the trustee's own view of where the best interests of the beneficiaries might lie. And the protector's role is merely to decide whether to consent to that. And as I've mentioned before, there can be interaction, there can be discussion, the protector can be an important sounding board, but ultimately these are different roles. The trustee decides whether to make the appointment, and the protector's role is a kind of watchdog role. It's oversight. The protector is not there to take over the trustee's decision making in relation to exercising the power. And this is particularly important when you consider that the settlor in all of these cases could have chosen to make this a joint power. It could be that powers to appoint capital would be exercisable by the trustee and the protector jointly. The settlor could even have conferred the power to appoint capital on the protector, but that is not what has happened in these cases. And it seems to me that if the settlor has chosen not to proceed in that way, then we have to respect the structure which has been set up that does that. Now, this is particularly important when you consider it in the context of my second point, which is, why would anyone choose to bake deadlock or the possibility of real deadlock into their trust structure? Because we should ask ourselves, what happens on the wide roll when trustee and protector disagree? So the situation I'm imagining is one where the trustees are considering the exercise of a power to appoint capital, and they form the view that doing X is the only proper thing for them to do. They wouldn't be willing to proceed in any other way. That's where they think best interests of the beneficiaries lie. The protector, on the other hand, completely properly on the wide roll, forms the view that Y is the only way to proceed and won't consent to anything other than Y. You have deadlock, but you also have both trustee and protector acting perfectly properly in accordance with their duty. You can't immediately say, well, one of them has gone wrong on the wide roll analysis. So what is the solution to that sort of deadlock? Now, it's interesting. I've talked to lots of people about this since September, and something I've heard reasonably often is, oh, well, everyone knows that really, when you give the protectors the right to consent to capital appointments, what you actually mean is that it's the protectors who get to decide where the capital ultimately goes. You know, they should be in the driving seat when it comes to the destination of capital. Now, it seems to me that not everyone knows that, and even if they do, it's probably wrong. First of all, because it's just not what the trust says. It could have said that power could have been given to the settlor, and there must in principle be some distinction between giving the protector the right to consent and actually conferring that power, the power of appointment, on the protector. You have to respect the structure that has actually been set up. There's also a tax context to this, which is if you are a UK settlor who has decided to set up an offshore trust with offshore trustees, then you very likely have sound tax reasons for wanting to do that. Your protector, on the other hand, may well be in the UK. They might not be, but they often are. That's often seen as one of the advantages, that they can be closer to hand. Would you really go to the revenue and say, well, actually, the way this trust works is my UK resident protector is the person who is really in charge of dealing with capital? I suspect that you wouldn't. So where does that leave us on the wide role in deadlock? Well, it's interesting, if you read ex trusts, you get some sense that actually the party arguing for the wide role may have thought that deadlock was a good thing, and that an unbreakable deadlock that even the court couldn't resolve might simply be the desirable outcome here. Now, I have to say that seems to me to be very, very strange indeed. More realistic possibilities seem to be that the trustees could surrender their power of appointment to the court, and then in accordance with the Supreme Court decision in the Letty-Markey case, the court would probably be able to break the deadlock by making the decision for itself. Though one might well say, well, first of all, the court is unlikely to want to accept a surrender and routinely declines to do so. And secondly, why should the trustee have to surrender in those circumstances? Doesn't that rather undermine their position in making this decision? Alternatively, you put the court in the impossible position of saying, well, who to remove? Everyone's acted in accordance with their duty. Remove the trustees, remove the protector, remove everyone. Well, I'm sure the court can do it, but on what basis would it decide? On the narrow role, this problem just doesn't arise. On the narrow role, if you reach deadlock, deal in a moment with the fact that you probably won't, but if you do, what do? Well, the trustees make a perfectly ordinary public trustee and Cooper blessing application, category 2, and say to the court, this is what we want to do, please bless it as being proper and lawful. And if the court does so, then on the watchdog view of the protector's role, their objections simply fall away. The protector is perfectly entitled to go to the blessing hearing and argue that it's not proper and lawful, but if the court decides that it is, then that's that, and the protector consents and the trustee goes ahead. So you will completely avoid the completely unnecessary deadlock that is baked into the structure on the wide role. Third point, very shortly, is at this point, some people say, well, okay, I accept all of that, but doesn't that really mean that the protector doesn't really have a role? You've reduced the protector's role to vanishing point on the narrow role analysis, to which I say, no, absolutely not in the least, because you have a protector who plays a key practical role in assisting the trustees to administer the trust. They act as a sounding board. Much can be done by consensus. They make sure that the trustees make a proper and lawful decision. How do they do that? Well, one of the most important ways is by making sure the trustees have everything that they should have in front of them. After all, a protector who is closer to the settlor or the settlor's family may be much better placed to say to the trustees, have you considered this? Have you thought about how this will affect that branch of the family? That was tried in the past. Are you aware what happened? And of course, these are all relevant considerations for the trustees to take into account. So the protector is perfectly entitled and would be expected to continue to have an active role. They're not required just to sit on their hands. But even beyond that, they can be a real watchdog with real teeth. Because if the trustee is going wrong, if the trustee is proposing to do something which the protector thinks isn't proper and lawful, the protector can slam on the brakes by saying, well, if you do that, I won't consent to it. So go back to the drawing board. So that's a huge advantage in practice, because it saves beneficiaries from being in the position where either they bring a breach of trust claim subsequently, or they go to court on a contested blessing, or even they seek an injunction to stop the trustees from acting. You can avoid all of that if you have an active protector who knows how to carry out the narrow role effectively. And it will only be in rare cases, as Justice Cayley said in ex trusts, that despite the interaction, despite the fact that a trustee who's sent back to the drawing board by the protector will, in the vast majority of cases, go back and have a rethink, there will be a very small category of cases where they reach real impasse. And in those cases, as I've already said, the court can very easily resolve it on a category 2 blessing. So it seems to me that what you have in the narrow role is a sensible, workable balance that gives the protector a real and important role whilst avoiding deadlock and respecting the completely distinct constitutional roles in the trust structure of the powers conferred on the trustee and the power conferred on the protector. But at that point, I have to stop and hand over to Gilead, who I'm sure will have something rather different to say on that.
Well, thank you, Michael. And I have to say that when you started speaking, I was slightly disappointed because you said that I was going to disagree with everything you said. And for the first 5 minutes or so, I thought what you said was pretty sensible. But I was relieved that the longer you carried on, the more I found to disagree with. So where to start? Well, I think the starting point that we both agree on is that it always starts as a question of construction. It's open to a settlor to define more precisely the role of the protector, and what we're talking about in these cases is the default position if it's not explicitly clear as to what the protector is supposed to be doing. Well, given that it's a question of construction, one has to start by asking the question of what was the intention behind it. And it seems to me that Sir Michael Burt made two very compelling points. The first is that in most of these cases, the reason that a settlor has decided to include a protector, which isn't an obligatory part of a trust structure, the reason he's included it is because he's appointing a professional, usually a trust company, often in a faraway jurisdiction, comprising people that he doesn't know personally and who very often don't know the intimate details of his family and his wishes. And so the reason he wishes to have a protector is to have someone who can effectively speak on his behalf and who does have that kind of personal knowledge. The second point, which seems to me even more telling, is that Sir Michael Burke says, if it were the case that the only function of the protector was effectively to take the role of the court in a public trustee and Cooper application, that is to say, to decide whether or not what the trustee was proposing to do was or wasn't lawful, and took into account all relevant considerations, etc., then the key qualification for any protector would be a legal qualification. And that is plainly in practice not the basis on which the majority of protectors choose their, the majority of settlors choose their protector. They want someone who is personally known to them, who can speak on their behalf. So those seem to me two very compelling reasons why it would be very surprising indeed if in the default position, what the settlor wished the protector to do is simply to make the same decision that a court would make if an application were made by the trustees for public trustee and Cooper approval. Now, getting back to the points that we agree on, I do agree that the trustee is in the driving seat. It is the trustee who makes the decision, and the roles are different. But the role of the protector, it seems to me, can be seen as quite closely analogous, and this is a point that Robert made in his opening comments, that it's analogous to a letter of wishes. The difference being that it's a letter of wishes with teeth. So the protector not merely stands to articulate what the settlor would like to see, but to act as a positive brake if something the trustees are proposing to do is something that he feels the settlor would never have approved of. And he can withhold his consent, even though the proposal itself is within the trustees' powers, and even though they have taken into account all the things that they should have taken into account and not taken into account anything they shouldn't have. So it seems to me that there is a clear and distinct function which is different from that of the trustee, but which is also different from that of the court. It's also, I think, relevant, and this is a point that's sometimes made, it's made on both sides of this argument, that it's costly for trustees to go to court and get directions under public trustee and Cooper, which is true. But of course, if the protector if there is a protector, and if he is remunerated, which would very often be the case, then there is a steady and consistent outlay. There is a cost of having a protector, but there is also a cost of going to court. And it seems to me that those two really cancel one another out. It may be that there is an intermediate point, and that if you're on your side, you don't wish to argue for the complete narrow view, and that the distinction is really between the wide view and the slightly less wide view. And you may find some way of formulating a constraint on the role of the protector that stops short of saying it is essentially just a matter of deciding whether what the trustees propose to do is technically lawful or not. I don't want to go on for very much longer, and I think that probably in the interests of time I ought to hand over. I would just like to raise one question really for Robert Ham, because as you know, in the course of Cowley's judgment, he referred to that very learned publication, The International Trust, which the relevant chapter, as Robert said, is written by himself, Emily Campbell, Michael Tennant, and Jonathan Hilliard. And Cowley quoted a couple of paragraphs, but this seems to me the key one. He said, and this is a quote from the chapter, "The aim of the appointment of a protector is therefore to monitor the trustees in the administration of the trust, on one level to prevent those trustees from abusing their powers or breaching their duties," well, that I can see is the narrow view, "but also to ensure as far as possible the trust is administered in accordance with the wishes of the settlor, at any rate in the case of the more important decisions and often on a day-to-day basis." Now, what I found puzzling about the reliance on that passage is that Cowley immediately goes on to say that this text supports the narrower view. And it seems to me, on my reading of it, that it supports the wider view. Robert, can you throw some light on that?
Almost certainly not. It seems to me that arguably it supports both views. And that would be consistent with the way in which the editorship of this chapter has proceeded. The passage which Mr. Justice Burts relied on in Pugachev was written by me, not David Hayton, but was greeted by my co-editors with such hostility that two of them threatened to resign from the project if it appeared. So I think, I don't think that chapter necessarily deserves detailed analysis of the sort that you suggest. But can I go on to consider the next point, which is whether we should, these difficulties having been revealed, be trying to answer them in trust instruments. I was at a conference in October where, to my surprise, I was the only person who had, or at least admitted to having, tried to define some of these issues in trust instruments. And I've done so over a long period of time in two contexts in particular. One, back in the days when we were exporting English settlements for CGT reasons, and there wasn't already a mechanism in place in the original English settlement, and the other being where you have a settlement where the settlor or the principal beneficiary is insistent that they should be, quote, their own protector. And for those in that context in particular, I have frequently drafted provisions not only saying what one commonly does see, the protector shall be a fiduciary, but also spelling out what that means, and in particular the role of the protector to exercise independent judgment, not just simply to transmit the views of the settlor or the principal beneficiary. And that is what one might call an anti-Pugachev clause. And I think it is sometimes helpful to spell out what fiduciary obligations look like in this context. I have to say, I think it does come as a surprise to some protectors to discover that they're supposed to exercise independent judgment, because lots of them think that their role is to transmit the views of the settlor. And it's also, I think, a surprise to some of them that if they have a fiduciary power, they have from time to time to consider whether to exercise it. But be that as it may, what I've tried to do less often is to deal with the question that we're really concerned with in the present context. Given the range of possibilities and uncertainty that there is, it seems to me obvious that one should try and resolve the uncertainty. And I guess how you resolve that may depend on how you answer the question whether you go for the wide role, the narrow role, or some sort of intermediate role. What I have done is to provide that where you have a power exercisable by one person with the consent of the other, the role of the party with whose consent is required is to assist the other party in the exercise of the discretion, and it is to be a subsidiary role. And the consequence of that, as I see it, is that in the event of a disagreement in good faith, the power holder's view should prevail. And that in that eventuality, the other party, the consentient, should do whatever is within its power to give effect to the view of the power holder. And I take that view, that is the view that I think is appropriate, essentially for a reason that Michael has already given, namely that if you expand the role of the protector, what you're doing is converting a power vested in the trustees with the consent of the protector into a joint power. And I don't see how you can get that as a matter of construction from words which give the power to the trustees and simply require the consent of the protectors. Claire?
Yes,
have you had to deal with this?
Yes, well, I was in PTNZ, and you're right, Michael, this was one of a very large number of issues on the shopping list for Master Schumann. But one of the questions which was raised in that case was whether it wasn't just a question of protector consent. There was also a power in the protector to remove the trustees. And I think when we're talking about drafting and we're talking about the role of the protector, one thing we need to keep in mind is that they often have a number of different powers. And so obviously the removal of a trustee might be seen as a fiduciary power. A power to consent might or might not be seen as a fiduciary power. And I think that if you are going to get into drafting to deal with all of the permutations and combinations, you need really to identify, well, when am I going to need this? What's the worst case scenario? Because at the end of the day, us litigators like going to court and arguing about things, but isn't it more suitable to have something approaching a shopping list for the protector to take into consideration when exercising a power to consent or not? Just going back to the discussion, because I can't help myself, I have to say something about narrow versus wide. My own personal view is that it should be a narrow, the role should be a narrow one. It strikes me as utterly bizarre that you would have a trustee who has power to make capital distributions, for example. It's exercised its discretion in a perfectly sound way, such that it could happily go along to the court on public trustee and Cooper category 2 application, and its decision would be waved through. But on the wide view of the protector, the big issue is going to be whether the protector will approve the exercise of the power. So in other words, you have an easy run going to court and persuading the judge, but the protector has an even more interrogatory role than the court does. And that strikes me as somewhat alarming. It just builds in, I think, deadlock into a trust administration. So then, sort of imagining the worst case scenario, you don't want the protector to act capriciously. You don't necessarily want the protector to be taking the side of one lot of the family against the other, or the mistress, or whatever the male or non-binary version of mistress is. You want there to be some readily understandable set of principles that the protector should follow in exercising the powers. And I think that's actually a very difficult drafting exercise to do. But as you know, I'm not a non-contentious lawyer, Robert, so I'd be very interested to know what you think about that.
Well, I have a question for you, Claire. I agree with you that it's a difficult task. But if you're concerned to set out ground rules for the protector, shouldn't you be setting out express ground rules for the trustees too?
Well, I think we've got the ground rules for the trustees are pretty wide, aren't they? They have to take into account all relevant considerations and ignore irrelevant ones. But in the context of a protector, don't you want something which is more akin to a box ticking exercise, so that the protector, who may not be a sort of professional services provider, knows the things that it needs to be thinking about? But my own view is that it could just end up being a completely meaningless exercise with the protector going through the list of factors, saying, yes, I've considered that, yes, I've considered that, yes, I've considered that, this is my decision.
If I could interject, isn't part of the issue here that when you draft in relation to trustees' powers, you do so against a pretty well-established backdrop of equity and certain statutory intervention in England and elsewhere? And so even if you have a very short trust, say a will trust, you nevertheless know as a trustee what your role is, because you can look in Lewin or Underhill, and even if your trust instrument says almost nothing, you know in the absence of express contrary provision what your role is. And I mean, I agree, Claire, that drafting at the moment in relation to protectors is likely to be very difficult, but I think that's precisely because we don't have that well-established, that default, the point that Diliad and I were really talking about. And I think, in a sense, that is why you can't entirely draft your way out of this, because even if everyone does as Robert is doing and tries to draft sensible protect provisions, nevertheless, you still need a workable backdrop, not just for those people who don't draft, but as the context against which that drafting is done. What happens if there's a point that you don't cover in drafting, which I think is, is almost inevitable.
Yes, I'm not sure that I'm persuaded that there's where you're dealing with discretions, that there's very much in the established role of the trustee, which is you can't transpose to the protector. But I suppose another question one has to consider is whether one should be writing in protections and rights for the protector. For example, should you have a charging clause? Should you have an indemnity clause? Should you have an exoneration clause? Jamie, have you any thoughts on that?
Well, I was going to draw a line under the wider and narrow debate for now and move on to some of our other bullet points. So I don't know if this is a point we want to do the poll or we want to come back to that later. No,
I'm hoping you're going to move on.
Okay, right, no, that's fine. We'll come back to that at the end then, perhaps. But I don't think I have anything that I can usefully add to my esteemed colleagues' contributions on the wider and the narrow rule, not least as so many of them were involved in these cases, whereas I was not. What I wanted to briefly discuss as part of this panel session is a topic that we think has not been as widely considered, even less so perhaps than in this trio of recent decisions. So just to recap, so far today, we've been exploring in terms of the role of the protector, perhaps as opposed to a trustee, as it's often contrasted. What rights, in the sense of powers, does a protector have to intervene in a trustee's decisions or to give or withhold consent, where that's provided for in a trust instrument? And as Robert said in his introductory remarks, another angle which has been much more widely explored than that, and on which there's now a relatively well-established body of precedent, at least offshore, is the extent of a protector's duties and the extent to which their acts and omissions can be made subject to scrutiny or challenge, whether those are the same standards as trustees, in particular fiduciary standards, and whether the court has the same ability to police and intervene. And without wanting to go into that larger topic, because as we've been saying, that's an area where there is more case law, there is more guidance. It's now relatively well established that a power given to a protector in a trust deed may, on its proper construction, be a fiduciary power, as opposed to a beneficial one the protector can exercise as they see fit. And a number of further conclusions have followed from that, such as the ability to potentially remove a protector or require them to provide information to the objects of the power. Now, coming back to what I started, what we want to focus on is a slightly less commonly discussed topic of a protector's rights in a different sense. What protections is a protector themselves afforded? And are they the same as those afforded to a trustee? And Michael and I thought we would take as an example for the purposes of this discussion and the indemnity out of the trust fund. Now, by way of a starting point to those who may not be in any way familiar with this topic, it has been held in a number of jurisdictions that a protector who holds fiduciary powers may be entitled to an indemnity out of the trust fund for their reasonable costs that they have properly incurred in relation to the exercise of their office where they hold fiduciary powers. And the most instructive and certainly interesting case that I'm aware of on this point is that of the Guernsey Royal Court in Re K Trust, a 2015 decision, which has quite an involved set of facts. But just to summarise the key parts of the decision of these purposes without touching on most of those facts, the protector's costs and expenses whilst they were in office had to date been met by the fund, and they had been in office quite some time from the outset of the trust. And an application had been brought as to their retirement/removal, which I think is a fair summary of the state of affairs that I won't go into beyond that. But the court was unwilling to grant any general indemnity in the abstract in favour of the protector going forwards after their retirement. Rather, the court held that any such indemnification should be approached on a case-by-case basis, where a particular liability and risk of that liability arising had been identified, so that all of the interested parties could express a view in the usual way. And the court decided that it was enough for it to hold that the protector's removal was proper, and so in and of itself did not give rise to any liability, and to hold that the protector's duties had been of a fiduciary nature, such that it was properly entitled to the indemnity it received to date, and that no further relief was proper or necessary. And this, for example, differentiated the case from a number of decisions in Jersey, which had awarded an indemnity concerning the costs of certain specific proceedings on which the person in question had become embroiled. I've described it in that way because they weren't actually protectors, to my understanding, in those cases, but they held fiduciary powers and exercised them in a similar way.
So, Jamie, is that effectively saying that if you're a protector, that you are protected for the period while you're in office in relation to some kind of indemnity, but once you've left office, once you've retired or been removed, then you're on your own, or we just don't know the answer?
I think that's right, Mike. I think I'd agree that that is where Re-K appears to leave us. It seems to have accepted that the starting point was that there was an implied right to indemnity, even if the trust instrument is silent as to this. And of course, in the usual way, unless the trust instrument expressly provided otherwise. And this was based on the fact that such protection followed from the burden of the office of holding a fiduciary power. In other words, the benefit flowed from the burden or should attach to it. And by analogy to that, this was the position for trustees. However, once the protector had left office, it was no longer possible to say that they were incurring costs or expenses associated with that office in the way that I've just set out. And so the basis for an indemnity fell away. And the court expressly was not willing to impose the sort of contractual indemnities upon retirement that the protector was seeking going forwards. And so it was held that the protector was going to have to look to the trustee for protection going forwards, who might meet any liability that the protector found they had incurred from the trust fund if the trustee considered that that was appropriate in the exercise of its own powers. And the court in effect held that a similar burden fell on the protector to that of a trustee to establish there was a liability that ought properly be paid from the fund, and the protector had failed to meet that burden. So in short, yes, it would seem that while the protector's in office, they may have powers similar to that of a trustee, but fundamentally their position is weaker than that of a trustee.
So, I mean, are we back now in the kind of territory that Robert was talking about in relation to drafting, where actually we may have law here which is barely adequate to the task in dealing with protectors' indemnities, but actually going forward, we should all be thinking quite hard about whether we want to make express provision in our trust instruments for dealing with the position of the protector, not just in relation to what their role is, what their duties are, but also in relation to the protection, indemnity, exoneration, and indeed whether professional protectors, if they're one very occasionally might come across such a thing, may well start to say, well, hang on a minute, I want the kind of clauses that trustees customarily have before I'm willing to accept this office.
And Michael, if I can interrupt, and might want to be paid for their work too.
Yes. I think very briefly the answer is yes and no. It comes back to yours and Gilead's debate about default rules. Re-K suggests there is a default rule to a certain extent, but no further. And so if you want to cover that gap, then yes, you will need to do so in your trust, or if you want to remove the default rule to the extent it exists, then again, yes, you will need potentially to draft to that effect. I think that probably brings us on to our final topic.
Yeah. Well, I was going to say the final topic, which is going to be Gilead proposing that we get rid of all these difficulties because there's no point in having protectors at all.
Well, thank you for that introduction, Robert. It slightly overstates my position. I do think that protectors are really a marketing device to persuade settlors who don't really believe in trusts to set up trusts. But I don't think it follows that they are completely pointless. I mean, what has happened over the last few decades is a movement away from the old-fashioned situation where the trustees were the family solicitor, someone who was personally known to the settlor, in favour of these professional trust companies. And even if the settlor takes the trouble to meet the directors of the trust company who are in office when the trust is set up, over the course of the trust's life, and it may even be a perpetual trust, the personnel is going to change. And it may change in the relatively short term. And so given the gap, and this goes back to what I was saying earlier as part of the debate, as to the motives, the intention of a settlor in appointing a protector, which does bring an additional level of administration and overhead to the trust. But in general, these tend to be very large trusts, and they can afford a bit of extra overhead. And what the protector does is to reintroduce the personal element. Now, I think I would probably accept that in an ideal world, the settlor would appoint as his trustees people he did know personally and in whom he had complete confidence. But the practicality in the real world is that that is increasingly unlikely. And so to that extent, I think it is a marketing device, and a perfectly proper marketing device for particularly offshore trusts to explain to settlors who may be reluctant from jurisdictions where they weren't familiar with the whole idea of a trust, to give up control, personal control, which they have exercised up till then, over a very substantial part, if not all, of their assets.
Good. We're coming to, indeed, I think we've exceeded our allotted time, but could I at this point please rerun the poll? While you're voting, can I tell you that in the original poll, the don't knows were the largest, or non-voters were the largest group by some margin. So I hope that we'll reduce the don't knows this time round.
Yeah, Robert, we also have one anonymous question in the Q&A. I wonder if there's time to deal with that.
Yes, I'm sorry.
Does it fall most naturally to Michael, perhaps, in his defence of the narrow construction, not wanting to necessarily lump him in it?
I'm afraid I can't see the anonymous question, but perhaps if someone would like to read it out.
I'm happy to take up that mantle. So an anonymous attendee has asked, on the narrow construction, surely the role of the protector could only be said to be as a money saver, i.e. to avoid going through court determination. All other roles except this seem to be capable of being fulfilled by the court. If the protector is not solely a money-saving tool under the narrow view, what else does the protector provide that the court cannot?
I can see how, if you were very cynical about it, you could come to that conclusion. But I think that rather undersells the massive practical benefit of the difference between a relationship with a protector who's able to say to you, hang on a minute, I don't think you should be doing that. That's taking you into dangerous territory. That's not the sort of thing you should be doing. And you thinking, okay, I see the point, back to the drawing board on the one hand. And on the other hand, actually making the decision, realizing the consequences, ending up in court, possibly not even on a blessing, possibly on a Part 7 breach of trust claim subsequently by the beneficiaries. I don't think it is just cost saving, although clearly it is cheaper to be told no by a protector than to go off on an unnecessary blessing application. There is a big practical benefit to the way that you run the trust as well. Do we have an answer on the poll?
Is it on everybody's screen or just mine?
Everybody. I think that Michael has won.
Yep.
Yeah.
Oh.
Congratulations, Michael.
Yes.
That seems the perfect note on which to hand back to the chair.
Thank you.
And we've cut down the don't knows too.
Well, thank you very much. You kindly dealt with the question and answer session as well. So let's move on by way of palate cleanser to private and public hearings in the family division context. What do we as trust litigators need to know about the family division transparency review and the case law emerging in its aftermath? Andrew.
Thank you, Jonathan. Well, good afternoon, everyone. Following that epic panel discussion about protectors, as Jonathan has said, we're now going to give a short talk about some developments in the family court's approach towards the publicity of hearings. Given the nature of this conference, we intend to focus on these developments from a trust litigator's perspective. As most of you will know, over recent years, there has been a trend within the English legal system towards transparency or open justice. And this reflects the principle that justice should not only be done, but be seen to be done. Of course, open justice is not a new thing. In the 18th century, Jeremy Bentham famously said, "Publicity is the very soul of justice." The policy justifications for publicity are obvious. It's said to improve confidence in the legal system and also to improve judicial decision-making. That said, full transparency in all cases would clearly go too far. And without some limit, such an approach may even become inconsistent with the administration of justice. And therefore, there are some circumstances in which it's necessary to safeguard the privacy of those affected by the court process. The most obvious example is where the interests of children are affected, as we'll come on to. So what we plan to do over the next 15 minutes or so is outline the recent developments in the increased move towards transparency in family courts. And then we'll consider what implications those developments might have for both onshore and offshore trust litigators. So Jonathan, what are the recent developments towards transparency which have been happening in the family courts?
Excellent. Well, let me start the transparency review and see if I can share the slides we put together. Is that working for you, Andrew?
Yes, it is, Jonathan. Well done.
Right, so I'm going to focus on the implications of the October 21 transparency review. I'm going to focus on its implications for divorce cases. There's a lot in there that rightly deals with family cases other than divorce cases, but our focus is on what the review calls financial remedy proceedings, or as are called divorce cases. So there are two things that come out of that. The first thing that comes directly out of that is reporting. The second thing, which follows in its aftermath, is case law on judgments not being anonymized. So I'm going to take the first, reporting, and then Andrew, you're going to take judgments. You can see from the slide I've put up the main conclusion of the transparency review. And the main conclusion is that the time has come for a change as to how family court cases are reported. That those who are able to attend them, journalists and legal bloggers, must be able to report more publicly on what they see and hear, subject to certain restrictions. And the main ramification of this for divorce cases is that it's proposed there's going to be a standard reported permission order, which will tell everyone what these journalists and legal bloggers can and can't do and what they can and can't see. And that was put out to consultation, and that closed on the 26th of November. So I imagine the final form of the order is going to follow relatively shortly, and that was consulted on by Mr. Justice Mostyn and Judge Hess, who are the allocated financial remedy judges. So what I want to do is explain what this concept of reporting order actually does, given it's not necessarily familiar to us as trust lawyers. And that the first thing to be clear about is what it's not. It's not suggesting that these hearings are going to take place in public. The default's still going to be that they take place in private. So at the moment, there's not going to be public access to these hearings beyond journalists and legal bloggers, but rather the focus of the change, as the slide suggests, is on establishing a slightly different regime that permits and facilitates the press and legal bloggers reporting. So what I want to do is focus on what the current regime is and how that's going to change. So at present, journalists and legal bloggers are able to attend divorce hearings, but what's going to change is what documents they can see and precisely what they can publish. So at the moment, they can do a number of things. They can name parties, they can publish photos, they can outline in very general terms the nature of the dispute. And of course, they can report anything that's already in the public domain, but they generally can't name children, because can't name the schools they go to, for example, and they can't publish any financial information that's obtained from the parties under compulsion without the leave of the court. So the sort of stuff that one sees going into the Form E's at the start of the divorce process, setting out assets and liabilities, they cannot publish without the leave of the court. And similarly, they're not allowed to see documents from the proceedings without the leave of the court. So it's often difficult for them to understand the detail of the hearing as they sit in the hearing and hear documents being discussed and debated. And what was felt was that those restrictions, the second and third restrictions, together rather emasculate the ability of reporters to report. So consequently, the two changes are to give them some access to court documents and open up, within careful limits, what they can publish. So they're now going to be provided with such documents as they request, limited to those that are necessary for them to understand the factual, evidential, or legal issues in the proceedings. So they can write around saying they want these, and they have to be provided to them within those limits. Now, as to what they can publish, the starting point is they can publish pretty much anything. They can publish a description of the factual, evidential, or legal issues, open proposals, quotations from documents, quotations from summaries of witnesses, quotations from the judgment. But then there's an exception to that, and then an exclusion from the exception. So the exception is they can't, subject to the exclusion, publish financial information which is given under compulsion, which is called protected financial information. So the Form E material, to take one example. But then there's an exclusion from that exception, which says that the following things shan't be regarded as protected financial information. One, a broad description of the types and amounts of the assets, liabilities, income, or the resources of the party. And two, open proposals, insofar as you set out the monetary value of those proposals and don't go into what the assets are. So taking all that together, the upshot is that journalists and legal bloggers can report in outline the assets, liabilities, and incomes and resources of the parties, and an outline of the open proposals, and they're going to get to see a lot of documents. And the other practical point that goes hand in hand with that is that to ensure they know what hearings are going on, in future lists are going to be made available in advance to them, identifying the general nature of the proceedings, the category of the hearing, and the time estimate. So that will allow them to decide what hearings to attend, rather than what's felt to be a slightly more haphazard method of doing so that pertains currently. Now, if all of that wasn't enough excitement, hot on the heels of that followed two judgments of Mr. Justice Mostyn, which Andrew's going to deal with.
Thank you, Jonathan. So the proposed order that Jonathan's been considering deals with reporting during the course of proceedings. And as Jonathan mentioned, that proposal was put forward for consultation at the end of October last year. Well, only a few days later, Mr. Justice Mostyn delivered judgment in a case called BT and CU, which provided him with an opportunity to consider the approach towards the publication of judgments in financial remedies cases. And it's interesting to consider what he said. The case concerned an application by a husband to set aside parts of a financial remedies order on the basis that his business, which supplied school meals, had allegedly been caused devastating financial hardship by the pandemic. The husband argued that this subsequent turn of events invalidated the fundamental assumptions on which the previous order had been made, and in accordance with the well-known House of Lords decision of Barda, he said the order should be set aside. Well, on the facts, Mr. Justice Mostyn swiftly rejected that application. But at the end of his decision, he then considered whether the judgment should be published, and if so, in what form. Mr. Justice Mostyn accepted that the current convention is that a judgment on a financial remedy application should be anonymised, although the decision whether to do so is ultimately for the individual judge. Now, in the past, that convention has been justified by reference to the need to respect the parties' private lives, the promotion of full and frank disclosure, and because the main information may have been provided under compulsion. However, Mr. Justice Mostyn now felt the need to take into account the increased move towards transparency, as well as his own consultation document, which Jonathan has told you about. As that consultation document explained, had journalists or bloggers attended the hearing, they would have been entitled, subject to any order to the contrary, to have named the parties and to have published anything which had not been disclosed under compulsion. In these circumstances, Mr. Justice Mostyn considered that this move towards transparency called into question the current convention that existed in financial remedy cases. He noted that there are many other types of cases in other areas of the law which require disclosure under compulsion or full and frank disclosure, or involve intrusion into parties' private lives. Yet judgments in those cases are usually given without anonymisation. Moreover, almost all appeal judgments in financial remedy cases are given without anonymisation. So accordingly, in Mr. Justice Mostyn's view, there was no longer any justification for this veil of secrecy to be thrown over details of financial remedies cases. And in his view, the convention was in fact another example of the family courts occupying what's been referred to as a legal Alsatia or desert island, in which general legal concepts mean something different. And that is, of course, reminiscent of the type of mistaken approach by the family courts, which was put right by the Supreme Court in Preston Petrodel on that occasion in relation to attributing assets to the husband. And therefore, Mr. Justice Mostyn signalled that going forward, his default position would be to publish financial remedy judgments in full without anonymisation, save that any children would continue to be granted anonymity. And any derogation from that default position would require distinct justification on the facts. However, the judge also accepted that in the case before him, the parties, relying upon the normal convention, had come to the hearing with a reasonable expectation that their anonymity would be preserved. And therefore, he considered it would be unfair to impose this change of practice out of the blue without warning. And for that reason, the decision BT&CU, as you can see from its name, was in fact anonymised. However, going forward, parties have been warned. And only 4 days later, Mr. Justice Mostyn reiterated this approach in his decision in A&M. And although the judge referred to there being some surprise about his decision in BT&CU, he doubled down and confirmed that his approach would be to publish judgments in unanonymised form going forward. And again, anonymisation was only granted in A&M because the judge accepted that the parties had approached the hearing in the expectation that the judgment would be anonymised. So the important practical upshot is that going forward, at least in a case before Mr. Justice Mostyn, the default position will be that financial remedies proceedings, including those involving trusts, which A&M was one, will be published in full without anonymisation. So Jonathan, what are some of the practical considerations for trust litigators arising out of these changes?
Well, the precise contours of this new approach plainly have to be worked out, and important points are going to include where the reporting permission order ends up, precisely when the judges decide that judgment should be published, what's going to happen at interlocutory hearings, where obviously in many cases you can have judgments on points of law, albeit not with the full documentation before them that will be available at trial, and whether over time this move to greater transparency ends up carrying with it hearing certain hearings or parts of hearings in public. But we've picked out 6 particular practical considerations we can see may arise. Now, the first of these, most obviously, is that those involved with trusts, including trustee settlors and beneficiaries, need to be prepared to have information about their trusts published in unanonymised judgments. Now, the important question, it seems to me, is one, are other judges going to follow Mr. Justice Mostyn? But assuming that they do, which has got to be a fair bet, when is there going to be a departure from that starting point of publishing an unanonymised basis? And what I can see as being particularly important to trust practitioners by the nature of the cases which we often deal with is whether arguments about children being damaged by revelations about the wealth of their family being put into the public domain are going to be accepted. Is the sort of approach that prevails in the Chancery Division per the V&T line, Mr. Justice Morgan, that only such restrictions are strictly justified, is that going to prevail, or is there going to be a slightly lower bar? And while we'll obviously have to wait and see, it seems important to me to remember that in divorce cases, to state the obvious, there are often, if not normally, going to be children involved somewhere in the case. And in every divorce case where the assets are of any value. It could be said that it would be better for the kids not to have an unanonymized judgment about their parents' wealth published from their perspective. But that doesn't therefore seem to me to be enough, or that would drive a coach and horses through the starting position. What do you think about earlier stages in the proceedings, of which there can obviously be many in complex cases?
Well, Jonathan, as you and I have discussed, it remains an open question how earlier stages of the litigation, i.e. pre-trial, will be dealt with. There are a number of ways that information could, in theory, come into the public domain early on, whether through unanonymized judgments on interlocutory matters or early reporting of the case. If sensitive information will become public very early on, shortly after a claim is issued, then that may well influence each party's approach towards the litigation. Of course, whether that is likely to be the case is usually going to be quite fact dependent. In some cases, the more sensitive information, perhaps about trust assets and the attitude of trustees, may not be disclosed or become known until quite late on in the proceedings. And generally speaking, one might expect early stage reporting or even a judgment on an interlocutory matter to contain less information when compared with the final judgment at the end of the proceedings. However, there will be some cases where information that the parties or a particular party would prefer not to enter the public domain may become public even very early on in the proceedings. So, Jonathan, what effect do you think this is likely to have on the approach towards settlement?
Well, the obvious question is whether it causes at least some people who are beneficiaries of trust to take into account the possible publicity of the trust in the proceedings as a factor in deciding whether, and if so, at what level to settle. And on one hand, as you say, there may not be much information in the case at the start of it. There will be some assets and liabilities, but not the full wealth of trust information, which will be at the end of the proceedings. So someone who's a beneficiary of the trust will have to ask themselves how they feel about an outline account being given at the start. Do they care about that? So that's absolutely fine. And how much do they care about it being picked over in more detail later in the proceedings, from which the answer may on the facts be don't mind at all any more than any other asset compared to sensitivity about it. So it'll have to be a factor to be taken into account. And you can see that in certain cases, there may be a perceived advantage to not having a full detailed judgment published. But many people might take the attitude that what really matters is whether details of their wealth are published. And if those are out, it doesn't really matter if there's a bit more detail about them. What about FDRs? Obviously, they're an important part of the settlement process, and one where there's been increasing use of private non-formal court FDRs.
Well, Jonathan, linked to the point you just made, I do think these developments could also lead to an increase in the use of private FDRs or arbitration to ensure matters are kept away from the courts. In the past, it's often been said that one consequence of greater transparency is that parties are more likely to opt for what is sometimes referred to as private judging. Now, for some, this is to be welcomed because it removes cases from the busy family justice system. Overworked judges are likely to be grateful for this. However, not everyone thinks it's necessarily a good thing if a deserving litigant is put off from using the court process by the threat of publicity. It could be said that this restricts access to justice. From a trust practitioner's point of view, though, if you are concerned about the confidentiality of your information, then the use of some form of private, non-court process may help to assuage your concerns. So I suspect that we shall see an increase in these private, non-court routes. Jonathan, what about considerations for offshore practitioners?
Well, key is the need to take into account the possible publishing of trust information into the public domain if one's advising a trustee about whether to disclose information to a beneficiary. It means that to the extent that one requires confidentiality undertakings, one has to be realistic that there's a limit to which those will hold in the situation where the beneficiary finds itself involved in a divorce case. I mean, I'd suggest distinguishing two sorts of cases. In case one is outside a divorce, beneficiary asks for information which ordinarily a trustee would be willing to provide. A trustee may feel they can't decline it just because one day the beneficiary will find itself in divorce proceedings, and that may get into the public domain. After all, it's an important part of holding the trustee to account. I mean, one does sometimes see trustees that don't physically hand any information out and require beneficiaries to come and look at it and not take it away. But putting those cases to one side, trustees may feel to some degree it's business as usual on that, unless they can think of a better way to cater for this. But if, secondly, in a different situation, a trustee's asked within the confines of a divorce proceeding, so once they're up and running, can I have some information because I need it to use in the divorce proceedings? Well, then a view is going to have to be taken, knowing full well that the information may go into the public domain. But often the fact set is going to be that at least something, and potentially a lot, is already known about the trust and in the divorce proceedings, or going to go into the divorce proceedings. And so providing some further information to enable a proper picture to be taken of the trust and show the family division that there's nothing to hide, to try to take the wind out of the sails of the counterparty arguing the contrary, may still be the way forward, but it'll just be another consideration to take into account. I mean, obviously, there may, though, be cases where, sadly, some impropriety has occurred somewhere, be it within the structure or linked to it in some way, and one may feel, well, they will only have themselves to blame the individual settlor or trustee in question. But what's the impact on that, do you think, of the increased drive to transparency?
Well, Jonathan, I do think that another consequence is that any wrongdoing that's occurred in relation to a structure in which the assets are held, well, there's likely to be an increased chance of the relevant authorities taking action in relation to that wrongdoing. I mean, even under the present convention, the court has a discretion to publish an unanonymised judgment and to send it to the relevant investigating authorities. It's sometimes said that a party who is guilty of wrongdoing has surrendered their right to privacy. However, in practice, it's been rare for a judge to decide to send a copy of his or her judgment to investigating authorities. I mean, one reason is because it's not considered the court's job to investigate offences not before it. It's also sometimes said that the courts generally tend to prefer promoting the public interest in the court having all relevant material before it, which might be undermined if a litigant considered there to be a risk of his or her disclosure being forwarded to authorities. Although these cases are rare under the present approach, I was in fact involved not too long ago in a divorce and trust case in which this did happen, where the husband was found to be guilty of serious and repeated frauds. Now, given the nature of the wrongdoing, the judge published an unanonymised judgment and directed that it be provided to the relevant investigating authorities. And amongst other things, this was considered to be in the interests of third parties who might otherwise have been tempted to do business with the husband. Now, of course, if moving forward, judgments and reports of any wrongdoing are now routinely going to be published, then that material will generally be available to authorities, and there will be no restriction on interested parties directing the authorities to it. Finally, Jonathan, do you want to conclude by saying anything about the protections offered by private hearings more generally, or have we in fact now run out of time?
Let me do 1 minute on that. I mean, hopefully all this discussion shows that the different ways that information can come out or be kept in, and that calling a hearing public or private doesn't answer the question, or is itself only the first step in answering that question. That the question is rather more nuanced than that. And if we sidestep to the business and property courts, a private hearing keeps people out. It doesn't itself keep people within the proceedings from publishing material out with the proceedings. Obviously, family proceedings are slightly different in that regard, to confidentiality attaching to them, but save for the restrictions in the Administration of Justice Act, people can publish information out of private hearings. That's at least in England or in jurisdictions which adopt a similar procedural code. Of course, other offshore jurisdictions like Jersey treat private hearings slightly differently, and it can be a contempt of court itself to publish material from outside the private hearing. But all that takes us back to the starting point in relation to family proceedings, which is that what's important as trust litigators is to understand carefully what information can and can't get out of the proceedings that your clients are involved in, how public or private they are. And the recent transparency review and the case law starting to come out of it in its wake requires us all to reevaluate a bit carefully our assumptions as to how that works in the family context. And so we need to keep a close eye on where that goes to be able to advise our clients on that. Excellent. Do we have any questions? I can't see any. Andrew, can you?
No, I think we've stunned the audience into silence. I can't see any.
I can see the threatening figure of Fenner looming on my screen, who's very keen to get on with his. Hang on, you haven't turned you're muted, Fenner, at least on mine.
Thank you very much. Yeah, I was only jumping in because this is not so much a threatening figure as just an emphasis that this is a point that is live in every division. So even in just variation of trust applications, in the past 6 months, we have seen a sea change to anonymity. The Chancery Division judges and masters are more alive by the day to the issue of anonymity. They are limiting anonymity orders to minor beneficiaries up to the age of 18. They are limiting anonymity orders to beneficiaries in PI trusts up to when capacity is obtained. This is still very early days. It's a cultural shift, I think, across all the divisions, but all divisions, applications in all divisions, people dealing with applications in all divisions need to be alive to this particular issue. Mostyn has made has done a review in the family division, which obviously has particular aspects of it. But my God, the judges in all the other jurisdictions are very alive to this. And if you thought that the jurisdiction in the Chancery Division was outside this, this is something that is very close to the heart of Geoffrey Voss, our Chancellor at the moment. So if you're seeing what's happening in the family division, wait for 6 months, maybe a year at most. It will be reflected in the Chancery Division. So, and let me say to all our audience right now, I have not seen or discussed with Andrew or Jonathan this topic that they've been talking about, but this is really close to my heart. It's going to be affecting all of us over the next 12 to 24 months. And I know at least 3 members of our chambers have dealt with this in the past 6 months, and we will be dealing with this in the next 12.
Well, what's absolutely fascinating, without encroaching further onto your talk, is one, that there are going to be lots of judgments coming out of the family division dealing with things like when the rights and interests of children justify anonymization and no doubt a lot of creative solutions to deal with that, hearing part of hearings in private, public, things like that. But also there is the interesting feature of reporting, and that in turn tells you of other ways that things become public and private. So absolutely fascinating. Okay, but let me not eat up your slot anymore, because I know that.
And thanks for that. It was a fascinating talk. I couldn't help myself from adding to that because of how relevant that is to everybody's practice. Now, okay, thank you very much. Good afternoon, everybody. So we had planned this particular talk, which is all about trustees' costs and when you get to take costs out of the trust fund. We had planned this as one of the breakout workshops. So it was originally designed to be very much a hands-on practical session with not too much high-level law. Unfortunately, given the virtual environment, we've had to rejig this just a bit. So you still get the practical stuff, but you're adding in a little bit of theory just to pad out the area. Now, we're very sorry, but the virtual environment means that we just cannot be an interactive session. And it simply doesn't work when there are over 250 of you. Now, that's great. We love that there are over 250 of you, but we can't have breakout sessions. But if you have questions on points, or if you want to flag up a particular issue, put it into the chat session as we're going. We'll either deal with it now, or we will flag you an email later on. Last practical point, the questions that we are going to be dealing with have been emailed to you, or a link to the questions have been emailed to you. In case you missed that email, strangely, that should be popping up in a link in the chat bar right now. And yes, I can see it's from Hayley Eustace to everyone, and it's a long link. Click on it if you want to see our questions. I should flag it. I should just explain. You don't need to look at them. We're going to explain them as we go. So here's what we're talking about today. And here's why we think that it's of significant practical interest to everybody listening in today. This is about when trustees can pay their own costs. And that means when trustees can pay us. You, me, solicitors, barristers. Now, everybody understands the basic rule. A trustee is entitled to an indemnity out of the trust funds for their costs and expenses properly incurred, that's the phrase, when acting on behalf of the trust. And that's the old rule of equity, and it's been embodied for all trustees since at least the Trustee Act 1925. It's currently found in the Trustee Act 2000 at section 31. We'll be coming back to that. But what about that caveat that these expenses that you get an indemnity for have to be properly incurred? When do you not properly incur a trust cost? So, wait for a second. Lewin on Trust, 20th edition, puts it like this. In general, a trustee is not entitled to an indemnity if he incurs costs or liabilities in a transaction which is unauthorized by the terms of trust instrument without the request or implied consent of the beneficiary. Stuff them. However, if the trustee acts in good faith and the transaction benefits the trust estate, he may be entitled to an indemnity to the extent the transaction benefits the trust estate. Although, whether the indemnity is a matter of right rather than of discretion of the court is not clear. So this is fabulous. I mean, it just adds 3 more questions when answering one. First of all, what is an authorized transaction? Secondly, what is this possibility of claiming unauthorized costs if it benefits the trust? And thirdly, what are the arguments about whether this possibility is a right or a matter of discretion? So let's start with that really basic question. What makes a transaction authorized or not authorized? And on this particular point, Edward Sawyer, you've been looking at this.
Thank you very much, Fenner. Well, obviously, if a transaction or expense is expressly provided for in the trust deed or statute, it's authorized, and trustees can, in principle, obtain an indemnity for the expense if they're not acting irrationally or in bad faith. And if an action is expressly prohibited by statute or the trust deed, then if the trustee does it, it's clearly a breach of trust and it's not authorized. So your starting point there is the trustee can't be indemnified for the expense, which all seems clear enough. Now, the traditional approach, as we know, in statute and trust deeds has been to identify particular things that a trustee can do at the expense of the trust. So, for example, you'll find statutory provisions that say the trustees can pay for an auditor, pay for a valuer, pay for insurance, and so on. So all of those things are in principle authorized. But a lot of expenses a trustee might incur are not expressly set out in statute or in the trust deed. For example, there might be types of expense that hadn't even been dreamt of when the statute or the trust deed was written, like IT consultancy costs, for example. So if an expense is not expressly authorized in statute or the trust deed, does that mean it's unauthorized, so the trustee can't get an indemnity? And instinctively, the answer to that question is obviously no. There are bound to be perfectly sensible expenses a trustee should incur, which are not expressly mentioned in statute or the trust deed. What's not so obvious, though, is the rationale for why the trustee is entitled to an indemnity for these items of expense.
Okay, you say that it's not obvious why there's a rationale, but maybe you could say that there's an implied power to do these things. Could you find an answer to this as a matter of construction of the trust deeds, that there's an implied power to hire an IT consultant, to write a letter, to pay for the postage on the letter? I mean, okay, admittedly, there are some obvious issues. Is this a necessarily implied power or a usefully implied power? I mean, what about implied powers or analysis of this as a question of powers?
Well, yeah, you could look at it that way. And in fact, the James Kessler book on trust drafting suggests that it is a question of the court implying a term into the trust deed, that trustees can do things incidental or conducive to their express functions. And he draws an analogy with the vires of a company, where the court says it's an implied term of the articles or memorandum of association that the company can do things incidental to its objects. But I wonder if this implied powers theory is really right. As you mentioned, Fenner, could you really imply such extensive powers under the implied term doctrine? You'd have to satisfy the test of necessity. It's not enough for an implied term to say that such powers are merely desirable or convenient. Also, the analogy with company law vires isn't really apt, because a trustee has all the powers of the legal owner of property. If a trustee is a natural person, he has power to do anything an individual can do, like make a contract or borrow money or instruct an IT consultant or send a letter or whatever it is. So the trustee has the power to do these things by virtue of having legal personality and legal title, even if they're not expressly authorized in the trustee or statute. And I think the question of whether the trustee can be indemnified is not a question of whether the trustee has a power to do something set out in the trustee or the statute. The real question, I suggest, is whether the trustee has exercised the powers he has as a person with legal title to advance the purpose of the trust. And that's what I think the Section 31 of the English Trustee Act is driving at when it says that the trustee is entitled to expenses properly incurred by him when acting on behalf of the trust. Generally speaking, the purpose of the trust will include safeguarding, maintaining and investing the trust property so the beneficiaries can benefit from it. So if trustees reasonably use their powers as legal owners of the property for those purposes, you generally expect them to be acting for proper trust purposes and to be indemnified. And in fact, you can see that analysis at work in a case called White and Williams. And I'd ask Fenner if you could show a slide with an extract from that case. So this was a judgment of Mr. Justice Briggs in 2011. And the question was whether charitable trustees who'd entered into unsecured borrowings were entitled to be indemnified in respect of their liability under the borrowing. And the trustees had no express power of unsecured borrowing in the trust deed or under statute. And Mr. Justice Briggs said it wasn't a question of whether the trustees had power to borrow, because as individuals, they obviously had power to enter into a contract of loan. The real issue, he said, was whether they were entitled to an indemnity for the liability under the loan. And he identified the key question, well, it's halfway down the slide in this quote, where there's a sentence beginning with that. He said, the right of indemnity will largely depend upon whether the purpose for which the money was raised by an unsecured borrowing was a proper purpose of the trust, such that the borrowing and expenditure of the money was not a breach of trust. And thanks for highlighting it. So the true analysis appears to be, in order to be indemnified against the liability incurred, the trustee has to be acting for a proper purpose of the trust. And if they are, then they're likely to be able to obtain indemnity, even if there's no express authorization in statute or the trust deed. But if the trust deed or statute expressly prohibits the trustee from acting in that way, then it's most unlikely to be a proper purpose, and so they won't be indemnified. Fenner, I think you're muted. I think you've come in there, but you're on mute.
How about this? Thank you. Can you hear me now?
Yes.
Excellent. So thanks very much for that practical and useful analysis. And let's put that into a factual context. So we're going to deal with now the first of the problems and questions on our list of questions and problems. So problem one, you've got a trustee co-limited, simple as you can be, is the trustee of the new money property investment fund, and assume that this is a real property investment fund. It's got wide power of investments in real property, but they are subject to certain administrative restrictions. You've got advice from accountants and authorization from an investors committee. We're trying to build this on what we see as quite common unit trust investment structures that you see around the world. And here, just for legal simplicity, assume all other powers of investment are excluded. The trustee co-limited decides, for whatever purposes or whatever reasons it's got, to spend some of its money by way of two things. First of all, buying non-fungible tokens, NFTs, and yes, we added that because it's entirely in the Daily Mail in the last few months. And secondly, maintaining some real property that it already owns. In neither of these cases do they get advice from the accountants or authorization from the investors committee. So if there's a proviso, if there's a mechanical proviso, they are in breach of it. The question then is, do they get their costs? I mean, the broad question is, can Trustee Co-Limited get those costs out of the trust fund? First bullet point on this slide. And we'll start with the maintenance costs. Ed, does the trustee company get the maintenance costs out of the trust fund?
Well, normally a trustee of land can spend money maintaining real property, and under English law, there's a power under Section 6 of Talata, and more generally, the purpose of the trust would include safeguarding the trust property by spending money to maintain it. Now, in this case, it may be that the purchase of the land was a breach of trust, but once it's acquired, the practical reality is that the land needs to be maintained. So you would generally think the trustee is acting for a proper purpose by spending money to maintain it, particularly if the maintenance helps to prevent a loss to the trust, which is the second bullet point on the slide.
Okay, so what about leaving aside the real property, which is a relatively straightforward and obvious answer, and we all know the practicalities there. What about this new type of asset, non-fungible tokens? Let's say the trustees have incurred expenses on the NFTs, for example, IT costs or extra special advisor costs. Can they recover those costs?
Well, the acquisition of the NFTs was obviously prohibited because it wasn't land, so it was an unauthorized investment in a breach of trust. So prima facie, the trustees aren't acting for a proper purpose, so they can't get an indemnity.
Okay. What about if they turn a profit? What about if they're making money for the scheme? You invested $100 and it comes out $1,000. What about the proviso in the statement in Lewin that you might be entitled to your costs if you make a profit?
Okay, well, so that's the third bullet point on the slide. And what you said at the start, Fenner, was that Lewin suggested that if the trustee had acted in good faith and the transaction benefited the trust estate, the trustee might be entitled to an indemnity, even if it's an unauthorized transaction. And so in support of that analysis, you could say, well, there's an old rule of equity that a trustee will be protected in acting as a reasonable and prudent man, as he might fairly have acted for the common benefit of all the beneficiaries. And I've taken that from an 1838 case. So applying that here, potentially a court could order an indemnity as part of its inherent jurisdiction to secure the good administration of the trusts. Possibly in this case, the trustee would struggle to say that the purchase of NFTs was in good faith and prudent. But let's assume they can get over that hurdle. That brings us on to the fourth bullet point on the slide, which is, do the trustees need to apply to court to get the indemnity, or could they just take the expense out of the trust fund without an order? And the answer to that point isn't really clear. Now, there is an argument that you don't need a court order so long as you've acted in good faith. And that's because it's a rule of equity that what would have been ordered by the court is equally valid if done without an order of court. And certainly there's a line of Australian cases that indicate that a trustee can, in this sort of scenario, take an indemnity from the fund without a court order.
I've got to say that this is a paradigm example of one of the problems of this particular area, which is that we have a whole host of generally useful but not actually specifically analytically clear judgments, which tells us generally where the court is going to go, but not why the court is going that way. And as a result, I think you end up with an uncertain legal circumstance that you probably should go to court with a lot of questions. Yeah, maybe we're entitled to this as of right, but it's not 100% certain. And we all know that if it's not 100% certain, beneficiaries are trustees are entitled to an application to court. So, next bullet point on slide, can it get a trust? And this is quite a technical point. Can a trustee get an indemnity if it is also contra liable for another breach of trust?
Right. Well, in English law, the cases say that a trustee in default is not entitled to claim on its indemnity. You have to make good the default first. It's a bit like purging contempt of court. Again, the Australian cases are more liberal about this, and they say a trustee can claim an indemnity even if he's in default. And it does seem that the English rule's pretty harsh, because it could lead to a disproportionate result where the trustee owes a small amount of money to the fund and can't claim an indemnity for a huge liability he's incurred. So you could argue that in that sort of situation, there ought to be some kind of set-off so the trustee can claim an indemnity for the balance, at least.
Yeah, and I know that you do have cases where a trustee in bankruptcy can claim for the difference between those assets or the liabilities.
Yes, absolutely.
And if you can claim as a trustee in bankruptcy for the differences, why on earth could you not claim as a trustee themselves? There has to be an intellectual disjunct in those circumstances. Again, another case where I think in this particular area, the cases have not caught up with themselves. All right, last bullet point. What about if the liability on behalf of the trustee co-limited is just alleged? Some insane beneficiary has just popped up and said, you are liable for this, even if everybody looking at it says this is daft. I mean,
well,
surely we must have some clarity on that point at least.
Well, again, unfortunately, there isn't a clear answer, but analysing it from first principles, if there's merely an alleged breach of trust that liability is disputed, then it hasn't been shown that the trustee is in default. So you would think that the trustee ought still be able to claim its indemnity, because otherwise a mere allegation of fault could paralyse the trustee from incurring any trust expense. But maybe if the complainant has a strong case, an injunction might be ordered to stop the trustee indemnifying himself to preserve the position pending resolution of the dispute. Fenner, I think you're still muted, and we can't wait to hear what you're saying.
Thank you. Okay, thank you very much for that, Ed, and thank you very much for telling me I'm muted. That was incredibly helpful and practical, in as much as you can be practical in the face of 200 years of conflicting and hopeless authorities. So, the Briggs case that you mentioned, White and Williams, raises a particular point that I have seen come up a couple of times, or 3 times in the past year. Powers to borrow. And in fact, this issue is what got me interested in the whole concept of authorized and unauthorized transactions. Because as you might remember, back in the day in law school, we were mostly taught that trustees didn't have any sort of powers of borrowing, at least no implied or implicit unlimited powers of borrowing. But again, the cases and the textbooks are a very complicated mess. And the cases say there's no unrestricted power of borrowing, but then they proceed to give fact-specific cases of where borrowing has been allowed, usually without giving any real analysis of why the borrowing costs were allowed in that particular case. And the Lewin summarizes it in 3 paragraphs that really highlights the chaos that is the authorities. Starts out with the concept of trustees have no unrestricted power to borrow money under the general law. So it's not allowable to borrow on the security of existing trust properties to acquire additional property. But then it goes on. Borrowing for certain limited purposes is permissible. If the trustee is short of cash, then the trustees may borrow in anticipation of trust income to be received later, provided there's a proper basis for their expectation the necessary income will be forthcoming at the time that the repayment becomes due. Blah, 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 blah. Trustees may also borrow unsecured in an emergency, for example, to stable possession of trust property by a mortgagee with a view to selling at a better price. I mean, that's pretty obvious as a practical point, but the legal analysis of it is more complicated. And then you get this 36.123 implied powers. Even in the absence of an express power of borrowing, the particular trust may warrant the inference that a power to borrow for limited purposes is implied. For example, a power to carry on the testator's business confers a power to borrow for that purpose, and a power to acquire additional lands also does so. So we're talking here in terms of powers. And then it goes on. If trustees properly hold partly paid shares, this is a very fact-specific case. Partly paid shares, they may seemingly borrow in order to penny calls and likewise may borrow to subscribe for a rights issue on the ground that in doing so they are preserving an existing asset and not acquiring a new one. So all the cases, and if you read them through, this is how it comes across. All the cases are about whether or not the trustees have a power to borrow. And that is exactly how the Victorian and the Edwardian cases approach this. It's a power issue. But for the reason that Ed has already discussed earlier today, I don't think that works. And I don't think it's even necessary. I think if you apply the proper analysis to this, it's again a question of why you are borrowing. Even if you have to bite the bullet and say, under Section 31 of the Trustee Act 2000, this falls within a proper application of trust property. Is it to pay for a proper trust cost in a reasonable proportionate manner, knowing that you can realize the cash later? Or is it to, for example, speculate or to conduct business? I mean, if you're not allowed to speculate, if you're not allowed to conduct business, then borrowing to do so is just an extension of, it's an action in pursuit of a breach of trust. But if you're expressly allowed to speculate, conduct business, X, Y, Z, doesn't matter, then borrowing to do so is fine. It's not a question of whether or not you have a power to borrow. It's a question of whether there's a purpose to do X, speculate, borrow, conduct business, which makes the borrowing pursuit of a valid trust action. And this is exactly what Miss Justice Briggs, as he then was, said or analysed in White and Williams. Now, White and Williams is a great case. I think it's an undervalued case that hasn't come to its highlight yet, but will in the next 50 years. I should flag up, it was a weird case which dealt with charitable trustees, and charity trustees have very specific legislation to do with secured borrowing that factor into an analysis of how this case works. But the principles that Mr. Justice Briggs said or applied to that case as to powers of borrowing or powers generally was applicable, I think, widely. You do have to be wary of one of the caveats that Mr. Justice Briggs put in that, and it's a paragraph 56, and he said, and this is a highlighted point, furthermore, unsecured borrowing, even for a proper purpose of the trust, may be a breach of trust if it exposes trust property to a permanent nature of attrition, for example, by enforcement proceedings to an unpaid lender. Now, I personally think that is just applying some sort of ordinary and prudent manner business test. So I think this doesn't add anything to the proper analysis. But be cautious of this because, as I say, Briggs has been undervalued so far, and you've got 200 years of cases to deal with. So with that in mind, and knowing that the cases on powers of borrowing are a chaotic nightmare, let's deal with this in a practical circumstance. Trustee Co Limited, same Trustee Co Limited, same trust fund, now has lots of solid but illiquid investments. They need to do something. They need to employ an accountant to give advice on a disinvestment and a reinvestment. But they have literally no cash, so they have to borrow to do this right now. No express powers of borrowing in the trustee. Can they do this? Can they borrow just to liberate their assets? Okay, so can they borrow? Will they be indemnified for the borrowed sum, capital, and the cost of borrowing, interest, if they do so? And I think the answer is absolutely obvious. Of course they can borrow. It's to do with investment, which is entirely authorized, assuming they tick the boxes as to how they perform their investment. Next question. Is there a difference between the capital and the interest on the borrowing? Again, it makes absolutely no difference. It's just a form of or a generation of liability on the trustee. There's a much more interesting, okay, for a given value of interesting, there's a much more interesting question of whether or how you pay for those costs. Does it come out of capital or income in the trust fund? And I say interesting because, you know, Robert Ham is going to find this absolutely fascinating. It's all to do with the analysis of whether a cost should fall on the capital or income of a trust fund. Trustee costs, if you're not familiar with this, trustee costs need to be attributed to either capital or income, depending on the nature of the action. Do they fall on the remainder man versus the life tenant, basically? And capital investment costs, prima facie, fall on capital, blah, 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 blah. But, and this is a really odd peculiarity, although it falls on one, capital, or two, income, they can be paid out of either capital or income and then reattributed or corrected later. So you can pay a capital liability out of income, and then you can, when you realize the capital asset, basically repay the income beneficiaries. This is a really well-established 250 years of authorities that say this. I don't understand why they say this, because it's borrowing from Peter to pay Paul. And how this is, and it's not just borrowing from Peter's paper, it's a forced borrowing from Peter's paper, where the transaction is necessarily not for the benefit of Peter. Because if it was for the benefit of Peter, it would have been borne by Peter anyway. However, this is definitely how the law stands. Anyway, something to flag up for you if you deal with this in the future. Last bullet point. Does it make a difference if they want to do something that is entirely discretionary, or they don't need to do anything, they could just stay put? Again, I think that makes absolutely no difference. It's not to do with whether or not you have a power, it's to do with whether or not you are acting in the interests of the purposes of the trust. So with that in mind, with borrowing done, let's turn to something akin to borrowing, which is litigation funding. Now, litigation funding, James has a particular interest in this area. Let's start with CFAs and DBAs. So conditional fee arrangements and damages-based agreements. Are there any problems with recovering the trustee's costs of a CFA or a DBA? And I say this as a matter of the trustee's entitlement costs. Let's ignore the legislation about CFAs and DBAs per se.
Thanks, Fenner. The answer is, I think, no, not in principle. The starting point has to be that trustees are allowed to hire lawyers. There will usually be an express power to do so, but in any case, so long as the litigation is a reasonable action for the trustee to take, as Ed has been explaining, as long as that's a proper exercise of the trustee's power, then the trustee should be entitled to be indemnified for their costs of doing so. So to take those two examples in turn, CFAs are probably just best seen as a particular price calculation mechanism for paying your lawyers. On that view, there's nothing legally different between agreeing to pay X pounds to your lawyer and agreeing to pay 2 times X pounds in the event that you win, as long as those are reasonable terms. One issue, of course, to bear in mind with CFAs, which a lot of the offshore cases discuss, is the usual considerations of whether this might offend issues of championship and maintenance, on which there is a fair bit of offshore authority now. The second category is DBAs, which might at first glance be thought to be a bit different, because there you're agreeing to pay part of the recovered sums to your lawyers. But it seems to me that, especially if the trustee is seeking monetary relief rather than complexities which might arise if the trustee is asserting a proprietary right over those assets, it again probably just a price determination mechanism whereby, as long as the trustee is acting reasonably on agreeing those terms, it is safe in respect of its indemnity. There's an interesting third category, which again might practically crop up increasingly in modern times, which is litigation funding. Once again, you might seek to categorize that as slightly different, because there you're not really hiring lawyers, you're in effect borrowing money from a third party on slightly unusual terms as to whether and how much you might repay. But once again, I think it comes back to the question that Edward has identified, which is, as long as it's for a proper purpose to do with the trust, in your paradigm case to protect trust assets and on reasonable terms, then a trustee is likely to be able to rely on its usual right of indemnity.
Okay, excellent. So let's put that into practical circumstance. Let's have a quick look at the problem. We've got a circumstance where some of your wonderful trusts, same trustee, some of the trust assets have gone AWOL, and the trustee co-limited wants to sue to recover them. There's no express power of entering into litigation funding. First question, can they enter into litigation funding full stop? Pretty simple answer given what you've said.
Yes.
Okay. Second question, slightly more sophisticated. If it recovers assets through litigation, can it use those assets, or indeed any other assets, to pay the litigation funding and pay its own costs of arranging the litigation funding?
Well, I'll give an unsophisticated answer to a sophisticated question, which is yes and yes.
Okay, which is nice because we're the people who get paid at the end of the day, particularly on the second bullet point. All right, so that's funding of litigation. But what about litigation costs generally? And again, let's put this in a practical context straight off. Let's put this in a slightly unusual type of litigation where the claim is against the trustee themselves about their trusteeship. So let's put this into context. Trustee Co-Limited has allegedly done something wrong. Say they've allegedly invested improperly in NFTs without committee authorization, and the NFTs are now of dubious value, £0. One of the beneficiaries is suing Trustee Co-Limited, and Trustee Co-Limited does actually have a plausible defense. It genuinely says that the committee did authorize. Question of fact, meh, who knows, 50-50. But it has no cash, no money, in fact, at all. No insurance, no cash, no assets. And the directors of Trustee Co-Limited are concerned about their reputations, their wish to ensure that it defends itself and hopefully survives the claim, but they have no money or insurance. Now, this is a complicated question. Can Trustee Co-Limited use trust funds to pay for their legal costs pending resolution of this dispute? So let's start with the basic one. Can they make a better application or a preemptive cost application to cover their costs, James?
Well, Bedo is going to be a naturally tempting option for a trustee, but the question for the court, as is well known, is whether the claim or defence of the claim is in the interests of the trust. Here, the general rule applies that apart from exceptional circumstances, it's inappropriate for a trustee facing a breach of trust claim to seek Bedo's relief. That is because, in short, defending the litigation is in the interests of the trustee, not the trust. Preemptive costs, if anything, even more difficult. By way of reminder of the distinction there, a preemptive costs order predetermines the order for costs in the main action. And the question for the court is whether there should be a departure from the usual practice of dealing with costs after trial. That's a difficult test to satisfy, especially on these facts. In fact, such orders are usually only made on Buckton categories 1 and 2, i.e. questions of construction of the trustee, that sort of thing. So I think here on the facts of the problem question, the trustee is in a difficult position.
That's a polite way of saying they're stuffed. Okay, if you're not going to make a better or preemptive cost application, does it have any other options here?
It does. They might not be particularly attractive. The first option is to not defend, allow the claim to go by default. Clearly unattractive on current facts, but one point to note is that if, for example, the beneficiaries are seeking removal of the trustee, and that is really what they are seeking to achieve, a trustee can always consider making a Part 36 offer saying, I don't admit any of the wrongdoing alleged, but if you really want me to go, then here is a suitable process for a replacement trustee. Second option, which is extremely risky both for the trustee and its own lawyers, is just to take the costs to defend the breach of trust claim. The third option is for the trustee to seek to make alternative arrangements, which I think brings us back to why the issues being discussed by Ed and Fenner, the powers of borrowing and the powers of entering into litigation funding, might have such practical importance in a case such as this.
Excellent. And you've already covered slightly the issue that the last bullet point comes up with, which is probably close to all of our hearts. Can Trustee Co-Limited lawyers, including solicitors and barristers, accept funds from the trust fund to pay for their bills?
Well, there's going to be a rather large question mark and some terrifying words, including knowing and receipt, if there is a situation where it is known or suspected that taking the costs out of the trust fund will itself be a breach of trust.
Yeah, this is a classic Carl Sifton number 2 question. We do not want to get into the issue of whether or not we have to pay back the cash that we've taken. It's just a bad idea. Thank you very much, James. That's enormously helpful. So that's the trustees' costs coming out of the trust funds. And when we were breaking this down, up popped one last aspect of costs, which is rare, or relatively rare, but very important. And it's third parties' costs coming out of trust funds. And this is the Berkeley Applegate jurisdiction, or at least covered partially by the Berkeley Applegate jurisdiction. And Barclay Applegate jurisdiction, or applications under that jurisdiction, deal with the costs of an insolvency practitioner appointed over a trustee, and when they can get their costs, and that's the insolvency practitioner's costs, out of the trust fund. Now, Graham, you've had a lot of experience in the cases, but for the other 250 people, including myself, to be blunt, this is a completely novel area. So can you talk us through this situation, starting with, and this is, as I say, noddy stuff, when on earth do you get these things, these Barclay Applegate applications arising? Are they only for liquidators, or is there something more broad in its aspect?
Thanks, Andy. The answer is it's a general principle. So most of the time you'll see it in the context of an insolvency practitioner appointment, but it's not limited to that. And I think that's one interesting point where there are gaps in the rules we've seen before. I think there is some room for some inventive use of this, particularly in offshore trust holding structures. The classic situation is a collapsed investment holding vehicle where there's client assets held usually in client accounts. There's mismanagement, commingling of assets, books and records are a mess, and someone has to go in to fix it. And that's ideal for an insolvency practitioner to go in. So two examples I've had recently were a $250 million Ponzi scheme property fraud, where there was still tens of millions of assets in the company. And there were fights between the investors as to whose money that was. And a failed online securities broker where there was $80 million of assets, but client cash had been used to prop up negative positions of other clients. So where you have those sorts of situations, not only can you use Barclay Applegate to get paid for the work to sort it out, be it you, the practitioner, or their lawyers, but you can also use MF Global type orders, which we'll get to try and resolve some of these issues in a quick and cost-effective way. But, sorry, Fenner, to go back to what you just said, it's not that narrow. There are cases such as Duke of Norfolk Settlement Trust where you can, where this principle is applied even to a normal de jure trustee who found out they had to expend a lot of costs in respect of work that wasn't contemplated by the trustee documentation. And I think where it's going to be useful is a lot of offshore trust structures. The private trust company may exist, but the actual assets are often held in normal trading companies or SPVs. The shares are held by the trust company or beneficially by the trust company, but the companies are operating as ordinary offshore companies, and a liquidator, a provisional liquidator or the like, could be appointed over those.
So one of the things that, and for me, this has been a voyage of discovery. One of the interesting things for me, looking at Barclay Applegate applications, is that it is reminiscent of, and indeed brushes up against, the principles as to where someone is an involuntary constructive trustee of assets. You may not get the ability to spend the money to argue about stuff, but you certainly get the ability to maintain or deal with or just administer the trust assets as a cost or a charge on the trust assets. And this is something that Ed and James and I deal with on a daily basis. It's so practical, it's actually quite difficult to find authorities to deal with this. There's Duke of Norfolk, which is a really useful case and is wheeled out in Chancery Division cases all the time. But actually, Barclay Applegate, I suspect, is a more useful case because it gets to the heart of the matter, which is how on earth do you deal with these assets and pay for the dealing with it? So with that in mind, let's have a quick look at a practical application of this question. And we're going to have a classic Barclay Applegate application. So Trustee Co. Limited are making complete balls up of the administration of the new money property investment fund and its own internal management. I'm adding in that because it makes things fun. It's so bad that provisional liquidators are appointed over Trustee Co. Limited, and there are allegations of commingling of funds and improper use of client monies. Records and accounts are a complete disaster. It's not clear which beneficiaries are entitled to what costs. The provisional liquidators realize that in order to just work out what has happened, they will need to spend some money. But we've heard this already. Trustee Co. Limited has no assets. The company also has a pool of trade creditors, and the liquidators, just to add to complexity or just add to their nightmare, has received a flood of letters from clients asking for their, in quotation marks, money back. And some of those claims are over assets which have competing claims, and some are over assets held by company in its own account. Can the provisional, and this is the big question, can the provisional liquidators take funds from the trust fund to pay for First of all, their investigation of Trustee Co Limited. Graham, hit me.
The one wrinkle, Fenner, that takes this once removed from the party who finds himself a constructive trustee is the liquidator has a role in the statute, which is to get in the company's assets. And the trust assets aren't company assets. So there needs to be some way to fund the work that's done in respect of trust asset. And there is a duality in the liquidator's role, and management of that role is going to be quite important. The great thing about Barclay Applegate is because it's usually done within an insolvency statutory or court regime, whether that's onshore or offshore, there is a court one can go to for directions to handle that. And the typical situation is going to be the question, disgruntled investors. Most of the cases are really investors who want someone else to do the work to give their money back, but they don't want to pay for it, and usually the court lets the office holder be appointed. They can be ordered on a preemptive or retrospective basis. On a case such as this, it is important, if possible, to get in quickly and get an approval. The core work that can be done is summarised in the Barclay Applegate itself, which deals with these three categories really. For certainly the first two, preliminary investigations, dealing with inquiries from investors, finding out what assets there are, account reconciliations, managing the investments. So those are the core things that one can do. But there's some more interesting things you can do. For example, the sale of the book of business has been approved under Barclay Applegate, where effectively investors can continue trading. That's in the interest of the investors rather than the company. And I think the last one, the handling of claims, that's the beauty where you can be inventive, because there is MF global orders where effectively the court will use a directions-based process to let clients assert proprietary claims over assets. And by analogy with proof of debt processes, the IP, whatever status they may be, a liquidator, provisional liquidator, or the like, can make a preliminary view as to whether to accept or decline that claim. Now, that has a great effect of whittling down the disputes to a rump of maybe harder cases. It also has a great benefit if money is paid away following that process. By analogy, in the cases referred to by Benjamin, those that are the practitioner and those involved with it are not going to be liable for breach of trust later on if the situation changes. So that use of Barclay Applegate and MF Global can be a really efficient way. Might not resolve all the disputes. It usually resolves a lot of them and focuses the mind as to what issues there are going forward.
And that use of MF Global orders as effectively as robust Benjamin orders is something that you would have expected to see the Chancery Division or the Chancery Courts doing years ago. It's quite useful to see it, or very useful to see it coming out of the commercial courts and coming out of the insolvency courts. There is one thing I want to flag up. When you talked about the wrinkle in the liquidator dealing with this because they have certain statutory roles, you can absolutely see it as a wrinkle. I personally see it as a forced, useful clarity, because what you're doing here, because of what becomes a Barclay Applegate order, is forcing the court to deal with an issue of who on earth is entitled to these costs, who on earth is entitled to these assets. And if you don't do this, no one's going to know what happens. If you've got a couple of people, A and B, who are arguing about a particular asset, I have no doubt that the liquidator could stand back and go, fight about it. If you've got 5, 10, 20, 50 different possible claimants, there's just no viable way for the liquidator to stand back and deal with this, or rather not deal with this and not be participating in how this is dealt with. And that comes back, as I said earlier, to the interesting point about unwilling or unconstructive trustees. How do you deal with this and know that you're handing over the asset to the right person and avoiding any particular liability?
Yes, and I think where the care has to be taken is a lot of the initial complaints you get from investors can come around the world from lawyers who may not know a lot about common law systems or trusts or constructive trusts or any of this. It's really great at cost of reducing those claims. Once one gets down to a dispute with a few number of parties, complicated facts, and or the issue really being between the company and the trust, the party asserting the trust, at that point this falls away. and you have to be careful to draw the line somewhere. There's the case Gill and HEC Enterprises, one about the members of Deep Purple, where the administrator in that case went too far in trying to be involved in resolving those disputes. So one has to be alert to where to draw the line, but it gets you a long way very efficiently, very quickly, in my experience, to resolve some of these fights.
Thank you very much, Graham. And thank you very much, James and Edward. And I see that we are overrunning our time. So I'm going to pass on to the next people, Brian and Elizabeth, to talk about forced heirship and trusteeship.
Thanks, Fenna.
Thank you very much, Fenna, for that introduction, and very, very interesting talk, if I may say so. Forced heirship and trusts, Liz and I. Look, for the most part, the subject of this talk gives rise to what are likely to be non-issues, and you may think it is a strange subject for a talk as a result. But what is interesting, apart that is from the extent to which it remains the case that forced heirship is a potential issue for trusts, trustees and their beneficiaries, is why it is that forced heirship and trusts may generally not be an issue in practice. Now, in this talk, we'll be addressing that particular why, as well as the limited extent to which forced heirship and trusts may be an issue nonetheless. As many of us will know from experience, forced heirs are quite capable of making mischief in trusts cases, irrespective of whether their claims hold water from a strict legal perspective or not. And it may require expensive and time-consuming Beddoe or public trustee and Cooper applications to have that which is obviously correct affirmed, and in the process to have trustee dealings and costs indemnities confirmed in order to deal with such matters. But this talk is not concerned with that. It is concerned with the strict legal position, not the many and varied distractions that may be set up in a case along the way. And with that, I hand over to Liz.
Thanks, Brian. So forced heirship, we're talking about rules which exist in many jurisdictions, in particular civil law jurisdictions, which limit an individual's testamentary freedom and which prescribe that a certain portion of a deceased's assets are automatically set aside for their heirs. And forced heirship rules differ very widely depending on the jurisdiction that you're talking about. First, they might differ in prescribing, well, they do differ in prescribing when the forced heirship rules apply. What will be the connecting factors to the jurisdiction? Generally, we're talking about nationality or habitual residence. And in some cases, Sharia law, we're talking about religion. Then we need to look at who are the heirs. Sometimes that will be the spouse and children. In some jurisdictions, it's just children. And in other cases, wider relatives will also be included. Then we need to look at what are the automatic shares prescribed by the forced heirship rules. Again, this differs. Some jurisdictions set aside almost all of an estate for heirs. Others will prescribe at a lesser amount, perhaps half. Then we get onto the really interesting questions of what are the estate assets for the purpose of forced heirship rules. All forced heirship rules apply to dispositions on death. But some go further and say that previous dispositions will be included as estate assets. And those previous dispositions made during the deceased's lifetime can or should have been available for the heirs. And this leads in some jurisdictions to clawback rules. And the question of can forced heirship rules affect lifetime dispositions, including, for our purposes, dispositions into trust. And in some jurisdictions, there's a time limit for these clawback rules. In France, there's no time limit, and you can look at dispositions for the entire lifetime of the deceased, and others apply rules commonly 5 years. And then there's the question of whether forced heirs have a personal or proprietary claim. Almost all jurisdictions give heirs a compensatory money claim only for the amount that their share has been reduced. Very few jurisdictions give heirs a proprietary interest in the deceased assets, and Sharia law jurisdictions are the exception in that regard. So in very general terms, there's two ways in which a trust might be affected by forced heirship rules. First, we've got what I'm going to call the simple case, where a trust is created upon death by an individual who's relevantly connected to a forced heirship jurisdiction, and it's created in a way which denies the heirs their share of the estate. All forced heirship regimes would say that such a disposition into trust is invalid or void. Then we have the clawback cases, and those are where a person makes disposition into trust during their lifetime. Now, some forced heirship regimes will treat trustees like any other third-party recipient in that case. So just to demonstrate the complexity of these rules, I want to give an example. So imagine that an individual settles a trust during their lifetime, at a time when they are not married and have no children. At the time, they are a citizen of a country with no forced heirship rights. Many years later, that individual dies, having in the meantime become a citizen or resident of another country which does recognise forced heirship rights, and they're survived by a spouse and children. The law applicable to the succession may well seek to invalidate the creation of the trust, even though at the time it was made, no one would have considered that it could be open to any challenge. Now, that example is given by the Ministry of Justice paper from 2009, which rejected the case for a general recognition of EU forced succession rules in the UK. The example demonstrates the scope for uncertainties in relation to private international law issues. Over to Brian.
In England and Wales and other common law jurisdictions having a common starting point as a matter of what may be described as common law private international law, the starting point is to recognise that forced heirship is a matter of succession. Common law private international law recognises that succession to movables is for the law of the deceased's domicile and succession to immovables for the lex situs. Now, it will be immediately apparent from what Liz has already said that there is scope for a mismatch here with forced heirship based on nationality or habitual residence. There is then the issue of characterisation. What is it that falls within the concept of succession? As a matter of common law, private international law, that is a matter for the law of the forum, that is, for the common law court adjudicating the matter, applying its own law. A disposition on death is clearly a matter of succession, which in the context of a disposition into trust goes to the rocket launcher, not the rocket, such that a disposition on death, if made in breach of applicable forced heirship rules, will simply be void. But dispositions into trust with a view to avoiding forced heirship are more likely to have been made inter vivos. And in that connection, there is a clear consensus that any clawback claims on the deceased's death to which the inter vivos dispositions are said to give rise will not be regarded as succession claims under common law private international law. And you can find that proposition in Dicey, in Lewin, in the Ministry of Justice consultation paper that Liz mentioned, and in a Bermuda Court of Appeal decision called Schindler and Garner back in 1992. Now, such clawback claims are not succession claims because they are claims in respect of property which is not in the deceased's estate at the relevant time. They are claims, if at all, in respect of property which, on a rocket launcher and rocket analysis, is squarely on board the rocket by the time the deceased dies. And the difficulty of any claimant's clawback case will be compounded by its personal, not proprietary nature, which, as Liz explained, most such claims will be. Now that is, as I've described it, the common law private international law position. But in pretty well every jurisdiction where a settlor intent on avoiding forced heirship will have created a trust, the common law position has been modified and superseded. And for that, over to you, Liz.
Thanks, Brian. So that takes us neatly on to enforcement issues and, of course, firewalls. So firewall legislation, as everyone attending this talk will be very well aware, is legislation which places a firewall between a local trust on one hand and foreign judgments and orders which might affect the trust on the other. So effectively insulating the local trust from foreign law considerations and displacing what might have been the position under private international law. Firewall legislation was first enacted in the Cayman Islands in response to concerns about forced heirship. But now all major offshore trust jurisdictions have firewall legislation, and you probably most commonly encounter firewall questions in relation to matrimonial cases and enforcement of matrimonial judgments relating to trusts. It's fair to say there's no standard firewall legislation which has been replicated across all jurisdictions, but there are many similar common features between the various rules. The firewall legislation can be said to contain both positive and negative provisions. So the positive provisions usually say things like decisions about the validity of a local trust or dispositions into trust or the capacity of the settlor will be determined by local law. The negative provisions will say things like no foreign judgment will be taken into account when determining the validity of a local trust. And it will say things like local law is prevented from giving effect to foreign forced heirship rights, for example, in relation to this talk. Some jurisdictions, and Cayman and BVI are examples, contain provisions which have an extended prohibition on the recognition of forced heirship rights at all. So, and that will be the case even where the trust is not governed by local law. And those kind of provisions might apply, for example, if you have a non-local trust, but which holds assets in the firewall jurisdiction. Then we need to look at what is the likely, or at least what is the intended effect of these types of firewall provisions. So in both the simple case, that's the one where the trust is created upon death, which heirs are trying to invalidate, and in clawback cases where you have a trust created during the deceased's lifetime, firewall legislation is likely to be effective against both types of forced heirship claims. And all of the firewall legislation that we've seen addresses forced heirship claims expressly, which makes sense because that's one of the reasons why they were enacted. And that will either be by referring to claims which arise, heirship claims, or claims which arise as a result of a personal relationship with the settlor. But you always need to be careful when you're looking at firewall legislation about when and how it takes effect. Is it only from the time the legislation was enacted or amended, or does it have retrospective application? So in some jurisdictions, Gibraltar, Jersey, and Guernsey, the firewall legislation applies to all trusts governed by local law whenever they were created. And in others, BVI Cayman, for example, the law applies only to trusts created after a certain date and or trusts which have been migrated to that local law after a certain date. Over to you, Brian.
So as Liz says, firewall legislation has in many common law jurisdictions, and pretty well all that are liable to be relevant in practice, amended the common law private international law of the jurisdiction. In each case, as Liz has said, it remains important to study the legislation for its terms and effect, including any possibly unintended consequences. So generally, to recap, as regards testamentary dispositions, but not necessarily, a firewall amendment will have caused the effective validity of such testamentary disposition to have ceased to be a matter for the common law private international law of succession. But that, of course, common law private international law of succession will nonetheless continue to apply in relation to dispositions to persons other than the trustees of a trust. And as regards inter vivos dispositions, such firewall generally, but not necessarily, will make clear that which is the consensus view as a matter of common law private international law in any event, that there is no basis upon which heirs can come along after the event and claw back that which has previously been the subject of a valid transfer into trust. There are undoubtedly some trusts out there which will have been made subject prior to applicable firewall legislation coming into force. And by way of example, there's obviously a window in some jurisdictions, as Liz has pointed out, between the promulgation of the Hague Convention, increasing trusts' consciousness, and on that on the one hand, and on the other hand, the introduction of firewalls. But generally, inadvertence apart, it's unlikely that property otherwise subject to forced heirship clawback will have found itself into a trust which does not have firewall legislation superimposed on it. So, what are the circumstances in which forced heirship remains relevant? Here, analogies with enforcement in matrimonial proceedings immediately come to mind, and 3 examples may be given. First, gaps in the firewall not otherwise filled by common law, private international law, and trusts law. These may turn out to be vanishingly small, but nothing should be taken for granted. Second, property located in a jurisdiction which recognizes the application of the forced heirship rules. Such property will be subject to whatever enforcement rights are recognized by the jurisdiction. And this issue is going to be most profound where property is directly or indirectly in the forced heirship jurisdiction itself. And 3, where one or more of the trustees is resident in the forced heirship jurisdiction, or advertently or inadvertently has submitted to such jurisdiction, which will give rise to issues for the trustee as regards indemnity, especially where the firewall legislation is in place. Now, as noted, as a matter of common law, private international law, clawback claims are generally considered impossible. The reason for this being that the property is in the trust at the time of death, and so not in the deceased's estate. And as such, any such claim is not regarded as falling within the law of succession, in respect of which a common law court would defer to another system of law. Now, this is a formidable objection, and the more so because of the consistent view in the literature, backed up by the Bermuda Court of Appeal, that it is determinative. Questioning it is very difficult and, frankly, liable to be impossible. But it's interesting as a final thought to toy at least with how an alternative argument might run, if only to see why it might be expected to go nowhere also. It's essentially a 5-step argument. Step 1, a claim as between heirs and trustees raises issues of the law of priority. Step 2, priority questions are generally speaking for the lex situs. Step 3, if under the lex situs the test of priority is bona fide purchaser for value without notice, most trustees, being volunteers, will take subject to any rights of heirs which may be characterized as mere equities. Step 4, characterization of the heirs' rights, that is, as to whether they are capable of amounting to mere equities, is for the court of the forum. Step 5, the fact that such rights may be in personam only is not determinative against this, since on the mere equity argument, property may be said in effect to have reached trustees from the settlor charged with a potential in personam clawback claim. Now, amusing as it is to formulate such an argument, problems with it are liable to be legion, not least that subject, of course, to the actual provisions of the forced heirship law with which one is concerned, the mere equity generally will not have subsisted at the time of the transfer into trust, and so the trustees will have taken the property received by them free of it. Which brings us essentially back to where we started, recognizing that the circumstances in which forced heirship are liable to be significant in practice are relatively limited. A reflection of that is the paucity of case law actually raising such issues so far as it has actually come to court. And the fact that pretty well all of these cases are going to be cases involving jurisdictions which have a firewall, which takes much of the fun out of the issue in practice. But that's not to say that when these issues potentially arise, they shouldn't be taken seriously. The conduct of heirs seeking to assert their rights often requires trustees to take them seriously. And naturally, whichever side of the argument you're on, you're going to want to look at the facts and the law, including the specific provisions of the firewall in each case, on the basis that nothing is to be taken for granted. And that's the end.
Thanks, Brian. I think we'll hand over now to Michael and Daniel.
Thank you very much, both. Right, we're nearly at the end. Michael and I will try not to overrun our time, and the subject of our talk is private foundations. But trust law is not an area that's famed for its rapid development, and as such, it's quite rare for trust practitioners to come across entirely novel legal concepts. One such rarity is the sudden explosion in the offshore world over the last 15 years or so of legislation permitting the incorporation of entities called private foundations, which are the subject of this talk. Because of their relative novelty, there hasn't actually been a great deal of litigation yet concerning private foundations, perhaps because the simmering family resentments that often underpin trust litigation haven't yet had time to boil over into full-blown warfare. But as private foundations become an increasingly large part of the offshore financial world, and for example, in 2020, there were over 400 registered in Jersey alone, we can expect that there will be a corresponding increase in litigation over the coming years. And it's in anticipation of that development that we're going to today try to do two things. First of all, I'm going to give you a whistle-stop tour of the anatomy of a private foundation and highlight a few points of similarity and difference when compared with more orthodox trust structures. And then Michael's going to delve slightly deeper into some of the areas which seem to us to be quite ripe for litigation and look at how some of those types of litigation might well play out. Now, because there are at least 13 common law jurisdictions by our count which have passed foundations legislation in some form since 2003, we can't hope to be comprehensive. And therefore, in both the paper and here, we're going to refer predominantly, where we do refer to specific provisions, to the position under Jersey and Guernsey law. And we've picked those two not because of geographical proximity, but rather because they are in some respects sufficiently similar to detect patterns, whilst also retaining enough points of difference to be interesting points of comparison. But before those of you who don't practice in Jersey and Guernsey switch off, I should say that there are many other jurisdictions whose legislation is very similar, in some cases almost identical in wording to either one or other of these. And so a lot of what we say should hopefully be able to transpose to some extent into those contexts. I should also say before the English lawyers all log out, that while England hasn't yet introduced equivalent legislation, and while, so far as we're aware, there's no prospect of it doing so anytime soon, that doesn't mean that foundations are of only academic interest to English lawyers. There have been cases in the High Court concerning whether, for example, a foundation domiciled abroad was a sham, or whether a right to receive assets from a foundation could be taken into account under the Matrimonial Causes Act. And there have also been overseas cases raising questions about whether, for example, the English tax treatment of assets settled under a private foundation, what the tax treatment would be of assets settled under a private foundation. So in a globalized world, foundations are even washing up on English shores. So what is a foundation? A private foundation, in fact, was originally a civil law concept, and rather like trusts, they have existed in some form since the Middle Ages. There are cases going back apparently as far as 1154 in which foundations were used for quasi-charitable purposes. Fast forwarding to the 20th century, and we find foundations having branched out beyond these charitable confines to become important instruments for asset management and estate planning across the civilian world, and most notably in Liechtenstein and Panama, where they continue to act to this day as sort of functional equivalents to the trust in jurisdictions that have no concept of beneficial ownership or fiduciary duties. For the seasoned trusts practitioner, there's much that will feel very familiar in private foundations, and a quick canter through the life cycle of the foundation will reveal some of these similarities. First of all, a foundation is brought into existence by a person, which can be either a real person or a legal person, called a founder, who is rather like the settler of a trust, who places assets into the structure and takes the initial steps to bring it into existence. The administration of the foundation will then be governed by an instrument drafted by the founder, or perhaps more likely by his or her legal representatives, This is generally called the Charter, and it will specify the purposes and objects of the foundation and will prescribe the powers and duties of those managing the assets. It's notable that while the legislation in all of the offshore jurisdictions provides certain skeleton requirements which the Charter has to comply with, certain matters which it has to address, the founder is otherwise pretty much unfettered in what they can include in the constitutional documents. Those powers and duties as set out in the Charter will then be vested in one or more people who will be called the council or councillors, who will have day-to-day control and have to act, first of all, in accordance with the powers conferred upon them by the Charter, but also in accordance with a general duty of good faith, which they owe to the foundation. It's also worth adding that the founder himself or herself can be a councillor. There may also be a guardian appointed who occupies a similar role to the protector of a trust. They're there to review and challenge decisions of the council. And finally, both the Guernsey and Jersey laws, and indeed many other jurisdictions' laws, include provisions that provide foundations with some protection from claims arising under forced heirship, the subject of Liz and Brian's very illuminating talk just now, and also matrimonial and insolvency proceedings brought in other jurisdictions. So we have a type of firewall in place. So far, so familiar. What about the differences? Well, first, because they're creatures of statute, equity has no role whatsoever to play in the administration of a foundation. There is no irreducible core of obligations imposed by equity, nor does the court have an inherent jurisdiction to regulate the administration of the foundation. This doesn't mean that there's no judicial scrutiny. Most of the legislation does provide for some sort of supervision by the court, and Michael's going to come on to say a little bit more about that in a moment. But the jurisdiction only exists insofar as it is provided for in the legislation, and this obviously affects both the breadth of the scrutiny and also the circumstances in which it can be invoked, albeit that may be mitigated to some extent by the supervision of the guardian. And while I don't want to reopen the debate from earlier, it seems to me to be at least arguable on reading of the legislation that the guardian's roles are more analogous to the wider view, so perhaps a small Pyrrhic victory for Gilead there. Secondly, a foundation is, like a company rather than a trust, a separate legal person. It therefore has complete legal and beneficial ownership of any assets which it holds. And this has two very important consequences. The first, which I will deal with in a sentence, is that perpetuity periods simply have no application to foundations. Although some legislation, for example, the Guernsey legislation, requires that the duration of foundations is specified, especially if the founder is a corporate person. Secondly, and this is perhaps the most fundamental difference and the most alien thing about foundations, it means that a foundation has no beneficiaries per se, in the sense that we as trust lawyers would ordinarily understand that word. Although there may be individuals or classes of individuals who are specified as objects under the Charter or other constitutional instruments, and although these are often referred to in the legislation as beneficiaries, in fact, they have no proprietary right whatsoever in the assets held by the foundation. The laws, for example, Article 25(2) of the Jersey law, does allow beneficiaries who become entitled to a distribution of property to bring what is in effect a debt claim for payment of that sum. But it seems to me that that's more analogous to a shareholder's right to seek an order for specific performance of a company's resolution to pay a dividend to the shareholder, rather than the more extensive proprietary rights of a beneficiary under an orthodox trust. The Jersey law, and indeed most other laws, also provide that a beneficiary is not owed a duty that is analogous to a fiduciary duty. Councillors, as I've said, do owe a duty of good faith to the foundation itself, just as company directors owe duties to the company rather than the shareholders. But the concept of the fiduciary duty to the beneficiary, again, simply doesn't exist under the foundation. Although it is worth noting that under the Guernsey law, the guardian actually owes a duty to act en bon père de famille, the equivalent in Guernsey of fiduciary obligation, towards the objects of the foundation. But the same is not true of Jersey and is not true in many other jurisdictions that have this type of legislation. Michael's going to come on to talk a little bit more about the position of beneficiaries, including their ability to seek information, but it will be clear from what I've said so far that the position of these so-called beneficiaries is quite a major departure from the position under trust law. And for some founders, the opportunity to limit the ability of beneficiaries to interfere may well, in fact, be a considerable advantage. Thirdly, the legislation provides four very extensive reservations of powers to founders. Now, of course, settlers of trusts can also reserve powers, quite extensive powers, to themselves, but they do so at the risk that if the reservations go too far, the trust may be held to be illusory on the basis that the settlor has not in fact divested himself fully of the beneficial interest in the property being settled. And everyone will be familiar with cases such as Pugachev and Webb where these kind of arguments were covered. Now, because foundations own their property completely, and because the foundation's legislation tends to expressly contemplate almost unlimited reservations of powers to founders, if they want to include that in the foundational documents, the illusory analysis appears to be completely inapplicable in the context of foundations. And therefore, this more extensive ability for founders to reserve various powers may be one more advantage of using a foundation structure. It should be noted, though, this doesn't mean that foundations are completely immune from attack. There is still the doctrine of sham, and it's analogous arguments that are often raised in the corporate law world. For example, in Preston Petrodel, the Supreme Court confirmed where a company structure is being abused as a facade to evade an existing legal obligation, it may well be appropriate for the court to pierce the corporate veil. And it seems to us that this should apply equally to the corporate structure of a foundation as it should to a more traditional company. And in fact, there was a case on foot in Jersey, which, fortunately for the parties perhaps, unfortunately for us, settled before trial, where some of these arguments were going to be run, called Dalemont Limited and Senatorov. And finally, whereas, unless you end up in court, including before Mr. Justice Mostyn, as Andrew and Jonathan were telling us earlier, trust can generally be kept fairly confidential. Because foundations have to be registered as corporate entities, there is at least some information which will have to be publicly available. Quite how extensive this is will vary from jurisdiction to jurisdiction. And again, I think Michael's going to touch a little bit more on this. But before I hand over to him, I should add that because of the statutory nature of these bodies, a lot of the questions that we're posing are going to have to be answered from first principles based on the language of the legislation. Existing authority from the trust context or the company law context will no doubt be instructive, and it's certainly worth looking at. But because of the differences between foundations and these more familiar entities, it's necessary, we think, to be cautious in uncritically transposing the approach taken in those areas into this developing one. And with that, I'll hand over to Michael.
Thank you very much. As Daniel said, I just want to spend a few minutes now thinking about how some of the typical types of litigation that we all see in the trust context might be played out in the context of a private foundation. So I'm not going to talk particularly about litigation to set aside foundations or the type of sham dispute that that Daniel was just mentioning. I'm thinking more about disputes over who should be the foundation's officers, which are analogous to disputes over removing trustees or protectors, disputes over the meaning of the foundation's constitution, disputes over the misapplication of foundation assets, and importantly, disputes over access to information about how the foundation has been run, what its assets are, and so forth. So we're really looking here at litigation which is internal to the foundation, and in particular, we're looking at the extent to which the beneficiaries of the foundation can access the courts and have their voice heard in the context of those sorts of disputes. In the trust context, of course, there's no difficulty about that at all because the beneficiaries have equitable interests in the assets, and the trustees have a duty to account to them. And the whole mechanism of trust enforcement depends upon there being one or more beneficiaries who are informed and in a position to assert the beneficiaries' rights against the trustees. Unsurprisingly, because of the very different constitution of foundations, that kind of relationship simply doesn't exist. So if we start by just looking at some of the key features of foundations for litigation purposes, if you look in the Jersey law, Article 25, you see that it provides that a beneficiary under a foundation has no interest in the foundation's asset and is not owed by the foundation or a person appointed under regulations of the foundation a duty that is or is analogous to a fiduciary duty. And then Article 26 says there's no obligation to provide any information to the beneficiaries, but that's made subject to an order of the court. So in the Jersey context, beneficiaries are really completely shut out from information and from
any proprietary rights in the assets or any duties owed by the foundation officers. Guernsey is a slight contrast. As Daniel said, Guernsey does tend to have a few differences with Jersey, which are quite instructive, because Guernsey has the concept of the enfranchised beneficiary, which is a beneficiary who is nominated as such in the constitution of the company, of the foundation. If they're not nominated as such, the default position is you're enfranchised. So you have two categories of beneficiaries: enfranchised beneficiaries and disenfranchised beneficiaries. And the enfranchised beneficiaries do have reasonably extensive rights to information. And if you only have enfranchised beneficiaries of your foundation, you don't need a guardian. So the implication there is that enfranchised beneficiaries are going to be in a position to look after their own interests. They don't need a guardian in order to enforce the constitution of the foundation on their behalf. On the other hand, if some or all of your beneficiaries are disenfranchised beneficiaries, or they are abstract purposes, then you do need to have a guardian, because those beneficiaries do not have any access to information in Guernsey, and therefore they need a guardian to look after their interests. And as Daniel has mentioned, in another contrast with Jersey, the guardian in Jersey owes duties to the beneficiaries, all of them, including the disenfranchised ones, a duty of good faith and a duty en bon père de famille, which is the duty which is imposed on trustees by Section 22 of the Guernsey Trust Law. So it's a duty to take care and to exercise prudence. So that's interesting in a litigation sense, and that is one connection between the beneficiaries and a foundation officer, which can be pursued presumably by a direct action. There is a duty, a statutory duty, but cast in traditional trust law terms of good faith and so forth, which is a direct to the beneficiaries. But subject to that, both in Guernsey and in Jersey, the only way that beneficiaries can actually bring a case before the court is by making an application under the statutory jurisdiction, which both Jersey and Guernsey confer on the courts. Now, that jurisdiction is extensive. It is statutorily based, but essentially the courts under these laws have power to do pretty much anything that a court would have power to do in the case of a trust. So it can remove and reappoint officers. It can give determinations on the meaning of the constitution of the foundation. It can give directions as to how the officers carry out their duties. It doesn't in terms say so in either law, but it clearly can order the provision of information, for example, to beneficiaries who might otherwise not have access to it. So there's a broad jurisdiction which the courts have. But of course, in order to access that jurisdiction, you have to be on the list of people who are entitled to apply. Now, in Jersey, Article 42(2) of the foundation law provides obviously that the foundation and the founder and officers and so forth can apply. It also says that beneficiaries can apply. That means in Jersey, any beneficiary. And in respect of a specified purpose, any person who, in the view of the court, can reasonably claim to speak on behalf of that purpose can apply, and the Attorney General as well, obviously, in the case of charitable interests. So there's a broad range of people in Jersey who can apply. In Guernsey, there's a similar list, but the disenfranchised beneficiary is not on the list. There is, however, a wind-up provision of any other person. So the court can allow a disenfranchised beneficiary with special permission to apply, but the general rule would appear to be that disenfranchised beneficiaries do not have standing to appear before the court. It's only the guardian on their behalf who can access the court's jurisdiction. But once you get the matter before the court, it's then quite interesting to to think about how beneficiary complaints about the way that the foundation is being run, or beneficiary requirements for information, or beneficiary requests that the councillors be removed and others appointed, is actually going to be handled by the court. And as Daniel says, there really is no case law at the moment about how the court is going to handle these types of applications. But the crux of them is that the court in every case has to act in the best interests of the foundation. And there's one interesting Jersey case called A limited against B in 2013. We'll give you the reference in the paper, in which Commissioner Clyde Smith had to consider some of these questions, and he considered them without really answering them. But he did, in the context of how the statutory jurisdiction might work, he suggested that there were some real questions about how the court should address the question of what is in the interest of the foundation. Is it the same as the interests of the beneficiaries? If it's not the same, and to what extent is the founder's view to be taken into account? To what extent should the court essentially seek to insulate the management of the foundation from the wishes of the beneficiaries in a way that perhaps trustees are not? I mean, if you think, for example, about an application to get information about the way the foundation has been run, which in a trust law context, the rules now, I think, we all know they're fairly well developed, but ultimately there is a right to be determined on a case-by-case basis for beneficiaries to have access to information about a trust. But the general approach, as we've seen in foundations, is that beneficiaries are not to be given information. Certainly in Jersey, they're not to be given any information at all. So how is the court going to go about determining whether it's in the best interest of the foundation for beneficiaries to be given information, which in a trust law context they might think that they were pretty well entitled to? Is the court going to decide it's in the interest of the foundation that beneficiaries should be informed so that they can then bring claims before the court? Or is the court going to say, well, the general rule is that you're not entitled to information, and as long as we, the court, are satisfied there's nothing seriously going wrong, we're simply not going to give you any access to information? Supposing that a beneficiary is concerned that assets are going to be dissipated, assuming that he has enough information to inform him of that, and he wants to go before the court for an injunction to restrain that dissipation. In a trust law context, it's easy because the beneficiary has a cause of action to in respect of the proper management of the trust assets, and he can simply go to court on the back of his cause of action and get an interim injunction if he can satisfy the requirements for that. But in a foundation, the beneficiary has no interest in the assets and therefore can only go to court under the court's statutory jurisdiction and ask the court whether the court would consider it was in the best interest of the foundation, essentially to give a direction restraining whatever transaction is the source of the beneficiary's concern. So again, the court here is going to have to decide really from first principles the basis on which it might accede to such an application. Is it simply going to treat it as if it was an application for an interim injunction, or are there other issues in play here? One might also consider situations around applications to remove by beneficiaries to remove council members themselves. In a trust law context, as we know, if the beneficiaries as a body are disenchanted with the trustee and have lost confidence in them, then that of itself may well be a basis for the court deciding it's in the best interests of the beneficiaries that they should have a new trustee. But if the beneficiaries attempt to interest the court to exercise its statutory jurisdiction to remove the trustees, Is the court actually going to engage with that? Is the court going to say, well, as long as we, the court, are satisfied there's nothing particularly wrong, you, the beneficiaries, don't have enough rights to entitle you to have a say in who the trustees should be. You just need to put up with them. And more generally, as we all know, there's a very common type of family dispute in which one side of the family attacks the trustees for being biased against them, the other side of the family defends the trustees, and there is protracted litigation over whether the trustees should or should not be removed between the objectors and the defendants, with the unhappy trustees caught in the middle. And in the trust law context, that can result in major litigation, again, because each side has a cause of action relating to the proper administration of the trust, which it's entitled, assuming it's not liable to be struck out for lack of a cause, for not having any prospects of success. Assuming that they get over that hurdle, they've got a claim which they can litigate to their heart's content. They can get discovery or disclosure, they can take it to trial, and so on and so forth. In a foundation situation, if you have a family dispute like that, all disenchanted side of the family can do is apply to the court and say to the court, please, would you consider removing the counsel because we think they're biased against us? And if the court says, well, no, then really that's the end of the matter. It's much more difficult for that kind of family dispute to escalate into major litigation, because the court operates as a sort of buffer between the beneficiaries, who only have such interest in the running of the foundation, really, as the court is prepared to allow them to have, and the council and the officers of the foundation. And it's no doubt one of the attractions of having a foundation for many founders, I think, that it is more difficult because of the corporate nature of the institution and the existence of the court almost as a sort of screening process through which beneficiaries have to go in order for any action to be taken against the foundation officers. It's actually an attractive feature of foundations, I think, for many founders, that they offer less opportunity, sadly for those of us who do this sort of work, less opportunity for protracted long-running family litigation of the sort which is all too common in the case of trusts. So, by way of conclusion, I think there are a lot of questions here, interesting questions, which remain to be answered about the way that courts are going to approach the interaction between beneficiaries, foundations, foundation assets, and foundation officers. I think beneficiaries will need to find their way quite carefully as to how, if they do have concerns about the way their foundation is being run, they're going to make those concerns known, how they're going to present their case before the court, and the extent to which the court is actually going to be prepared to entertain those complaints, even if they succeed in making them. That's really all I wanted to say. I think our time is up, so I'll hand back to Jonathan.
Perfect timing, thanks. And thank you everyone very much for attending today's webinar. We hope you found a number of sessions that tickled your fancy.